Well, good afternoon, everyone. Welcome back from the holidays. I hope everyone had a Merry Christmas and Happy New Year. I guess just as per usual, I'd like to remind everyone that our meetings are web streamed and televised, and for those in attendance, I would ask that you ensure that your phones are on silent mode. The agenda for today's special council meeting was circulated on Sunday morning electronically. As this is a special council meeting, nothing can be added to the agenda. However, there was an error. I had circulated to council to add a third item, and I guess it was misinterpreted by the clerk's department. So we will need a 2/3 resolution to add a third item. So if I could have a mover and a seconder that is previously identified, council add an item to the agenda respecting encroachment agreements through a waiver of the rules of order. All those in favor? And that's carried. And are there any declarations of pecuniary interest? Okay, seeing none. The first discussion item today is our CAO hiring process. I just wanted to run by my thoughts from council and hear your thoughts on the matter. But obviously there's sort of an imperativeness to getting this moving forward as quickly as possible. The applications did close in November, so we do have a number of resumes. What I was thinking was, Erin has joined us here today, was that we would ask Ms. Anderson to sort of long list between 5 and 10 candidates. She's indicated that she would be able to do so by this Friday, and either those long listed candidates would then go to council either with the council package if it's done in time, and if not, she would be able to email them out to council, and that we would add a closed session item to the council meeting for the 14th, the next week's council meeting. And as council, we could collectively then decide for a maximum of 5 candidates together of who we would like to see for the short list. And then from there, we've discussed, we had 3 days scheduled for budget deliberations, the 28th, 29th, and 30th would be to leave the 28th and the 29th as full days for budget and to begin scheduling interviews, full day of interviews for the 30th. We had not discussed who would be on the hiring panel. I think we had sort of talked about all of council. Ms. Anderson indicated to me in a phone call today that historically what had happened is they had the mayor and 3 council members on the first round of interviews, and then did a second round with all of council. I'm thinking, given if we can narrow it to 5 candidates or less for the 30th, I think my preference actually would be to have all of council there for the full day with the full 5 candidates and just get moving forward. So, questions, comments? Does that work for everybody? Okay, Erin, any comments from you? Well, why don't we let's discuss that component on the 14th when we decide who the candidates are going to be and how we want to move forward with that piece, and then who that person would be. And then the other piece as well, in terms of the questions, I thought that perhaps Erin could work on, a couple, 2 to 3 standard HR questions. And then we're going to need a couple questions that are focused sort of around this council and our strategic priorities and obviously some of the challenges that we're going to face in the year ahead. So I was hoping that perhaps council might indulge me that maybe I could work on that with Councillor Rabbits to determine those couple questions with his HR background. But if somebody thinks something different.
Just to highlight that there's been a number of rulings that this would form an official council meeting on the 30th, so I imagine Stephanie will likely be in the room with council as they proceed through, just as a fly on the wall.
Well, she also has an HR background too, right?
Yeah.
Perfect.
Only if anyone else wants to join in with the meeting when you're with Councillor Rabbits, I think that open it up, just let us know, and we can attend if we can. Sound good?
That sounds good.
Awesome.
Anything further? Okay, so that's the plan. Erin will provide us with 10 candidates by Friday. Council will narrow it down to 5 or less on Tuesday, and we'll plan for interviews scheduled with all of council on the 30th. Okay? The next item of business is the appointment of an acting CAO. In the past, as you know, we've had a rotating sort of cycle of CAOs. There's been a schedule, and I think we can all agree that that didn't work very well, especially as we're going into some challenging times ahead here. I think that Marlene is probably overwhelmed in public health with some of the challenges and changes that are going to be coming from the provincial government. I think that Mr. Godby, as we know, is up to his eyeballs in public works challenges. And I think that we have seen great leadership out of Mr. Cridlin over, certainly over this past year. He has been an enormous help to us in many regards. And if council sort of, I wanted to get your feeling, but mine would be to appoint Mr. Cridlin as the acting CAO. I have had a discussion with him to see whether or not he would even be willing or interested to do this, and he is. He has made it clear that he's not interested in the position long-term, and that this would be a short-term basis for council. So we would be looking at a maximum of 3 months, unless it was mutually agreed to be extended by council. And if we found a CAO in shorter period of time, Mr. Cridlin would return to his role, his current role. Councillor Roberts?
With that, and through you, I'm supportive of the nomination of Bill Cridlin for acting CAO. I think with the rotating mechanism that we had in place before, unfortunately it didn't allow our general managers to really to focus on their portfolios with a rotating basis. It was sort of, who's on first or who's in charge this leg, and having one person in that position, one main point of contact, one decision maker, is going to add some stability to the whole process while we fill the role. So having someone long-serving, Bill, he's worked in a variety of different departments as well. I think it's a good choice, and we're happy that he would be accepting that role. And I want to thank you for putting your name forward, Bill, because it's not an easy job to be a CAO. And with that, I think I'd like to move if we're looking for direction, or at least you have my endorsement to do that job.
Councillor Columbus?
Well, I would certainly support Mr. Cridlin to have this interim, or acting interim, I guess, CEO position. It's been around a long time, and I think we need some stability within Norfolk County, and he's the man to do it, or the person to do it, I should say. And I would second the motion, but I would like to hear from Mr. Cridlin as to his acceptance of what we're discussing.
Thank you, through the chair, to the county council. Mayor Chop approached me just before the break, and I did take some time to think this over. I do thank council, the mayor and county council for the opportunity. It's a huge job, as you've mentioned, a huge responsibility. Obviously, the first task at hand is the budget, so I can see being very busy with that. Still some details I was going to say to work out, but I have agreed to a 3-month, and I've told Mayor Chop that I will not leave council stranded. I know picking the right CAO could be done in 2 months. It may be 3.5, 4 sort of thing, but I'm here for the duration. I hope to be a maintainer, add some stability, as Councillor Columbus mentioned, for the organization. What else to say here? I hope as I'm filling in, I can also push some business along, and I do look at the budget details, and I just see that January that's going to be priority number 1. Personally, I'm very much an operational person, and with that, I like to make things work. So I'm hoping I can carry that drive and energy into a top administrative job and push some things along and get things moving that needs to be moving. I also want this, one of my goals is to be a very positive experience for not only myself, but for Norfolk County Council and the ratepayers. I look forward to working very closely with every member of council and the mayor on decision making and moving things ahead. So I'm definitely an open communicator. If there's anything you need from me or my staff, my door will always be open and my phone will always be on. And I guess with that, I'll just turn it over to County Council for any additional questions or anything. But no, I'm very pleased to be asked and looking forward to the next 1 to 4 months, we'll say.
Thanks, Bill. Any questions for Bill? Okay, so we have a mover and a seconder that Mr. Cridlin be appointed acting CAO for a period not to exceed 3 months unless by mutual agreement. And I guess if there's no further discussion, all those in favor? And that's carried. I just want to say thank you again, Bill. I think the next couple months, you're going to be invaluable to council moving forward through these challenging times, and we really appreciate you stepping up right now. Okay, the third item is in regards to encroachment agreements, and I know a couple councillors aren't on social media, but for those that are on social media, I'm sure that you can see the, I guess the vitriol that's been directed at this council over the past weekend. And I've asked Councillor Martin, it's a Port Dover issue, and she has put together a presentation basically to inform council of what has transpired, and then hopefully we can go from there with the discussion.
Thank you, Mayor Chop. If you don't mind, I'll sit just to go through this presentation. But I wanted to have a concise and clear way to kind of bring council up to speed all at the same time. For those of you who aren't aware, over the weekend there was a Ward 6 issue with regards to a patio. At the end of this discussion, I hope to bring forward a couple motions, but I want to give you as much information as I can and give you an opportunity to ask staff questions should you choose to. And it is my hope that we can not only rectify this particular issue, but rectify the issue at large should something like this arise again, and hopefully protect some business owners as well as Norfolk County in the process with a policy decision. Friday, I was made aware of, from a business owner in town, that he needed to remove his patio. I contacted staff. They were great at responding, and as well, they responded over the weekend, which is very much appreciated. But when I asked for some specific details or a meeting to communicate the direction, the messaging was essentially that council should stay at an arm's length from a bylaw issue and not meddle with a bylaw issue, as there was an order to comply for this individual already put out. And although I can see that that definitely has merit and it definitely protects council in certain situations, I would argue that maybe this should have come to council prior. There were a couple things that happened along the way that I could share with you. And if they couldn't come to council, and if I'm wrong, it would have been my hope that they were circulated to staff so that we landed on a different outcome. I just really feel as though it's not a priority right now with all of our staff being depleted and departments are working overtime. It's not a priority to end up in a situation where businesses are being hindered anywhere in Norfolk County, but especially in Port Dover where we have a massive water capacity issue and no development happening. We need to really be working overtime here to support our businesses. Now we sit around this table spending staff time and resources, the business owners' time and resources, and council's discussing this, which leads me to one of the attachments I've put on your desk here. You've got a couple pages of social media comments that are very upset with council. And I understand that that is a part of our job. I understand that that is something we have to deal with, but I really take exception with this particular issue, as it was a bylaw-related issue. It was not a decision that hit council's table. It was not a decision that council had any part in, and it was not a decision that council played a role in. And yet, we take an overwhelming amount of heat for this decision. And the reason why that's problematic for me is because this council campaigned on supporting small businesses. This council campaigned on finding efficiencies, better customer service, and most recently we made a strategic plan that asked our staff to find the yes in whatever situation they were working on. So the point of that first page is that, council, the buck stops with council. We are accountability. I understand that, but, I wanted to bring that to your attention. So if you bear with me, I'm going to go through this really quickly. In December of 2006, Mr. DeBono purchased the property now known as Southside Louise. In 2012 or so, he began the process to implement a patio on Norfolk County property through an encroachment agreement and lease. And this is a photo of the property when he purchased it, what it looked like. And in this particular photo here, you've got slides if you can't see it on the paperwork in front of you. This particular photo here, this is Clinton Street, where the patio was just a short week ago. I just would ask council to take a look particularly out front. That space highlighted in yellow is Norfolk County property. That space highlighted in yellow is pavement. That's how the individual purchased the building. That's what it looked like. And I would argue that there's quite a bit of crap outside of it that doesn't make it look all that lovely. The next slide is the side of the building. I believe the stairs are not even up to code at this point in time. You need to have a landing after a certain number of steps, and the building in general is in rough shape. And that's the front of the building. So here's a picture. The screens are a little delayed, but if you can see it up there. The side of the building. To the right is Main Street, and we're looking at Clinton Street. Again, you can see the rough patch in front. You can see a very large corner there, and there are no curbs. The sidewalk is, there isn't a sidewalk, period, in that space. So the landowner came to council, or sorry, he came to the county, and in 2012, he began the permit process to install the patio. This required a unique encroachment agreement with Norfolk County because we owned the land. It also included a building permit for the landowner, the business owner, which then led to engineered drawings, studies, a new sidewalk and curb, which the business owner paid $16,000 for, a Norfolk County sidewalk and curb. And then, of course, he spent the materials and installation for his own patio. When the agreement was granted and the lease was done with the county, he was now licensed and eligible for 60 extra patrons in his business and needed to make amendments to his business, including an upgraded kitchen and washroom to accommodate those individuals. And then this next slide here is an invoice demonstrating that he was billed for a lease agreement. And in the next slide on the left, you will see bylaw 2012-90 signed in May 2012 by then Mayor Trevally and Clerk Beverly Woods. And to the left, the actual agreement signed by Mr. DeBono. All is well in Port Dover, and a new patio comes up, a beautiful side of the building is put up, and you can see there's a large sidewalk here. You can see that the patio connects into a beautiful kind of beveled stone that is laid instead of where the pavement was, and there is a very large corner and full sidewalk there for the public to still access. If you look up to the left, you'll see that red building there. That's the Circle Game, and I'll remind you there was no sidewalk here. There was uneven pavement, but the sidewalk began in front of that red building there, and it is quite small, I would argue. So all in all, the point of that is that there's a lot of improvements going on here. In October of 2019, bylaw staff visited Mr. DeBono and told him that Norfolk County did not have a policy to allow for encroachments. And this is a bit of an error there, that it's in conflict with our obstruction bylaw and possibly other bylaws. So I'd like to just make a quick point here that this is not to the fault of our bylaw per se. They have a job to do and they can only act on the policy that we have for them. So at this point in time, his lease agreement has expired. It's not valid, but Mr. DeBono has spoke with staff. He's offered to buy the lands and he's asked to renew the lease. He's placed calls to Norfolk County to do this in emails, and he was told that there was no policy to renew the lease and that it would set a bad precedent if we sold the land. He would need to wait until 2020 for staff to work on a new policy for his patio to come back up. And in November 7th, a second inspection occurred, which resulted in an actual order to comply. He needed to officially, no matter what, remove this patio. That has been done. He has since complied, and now this is the outside of the patio. It's cleaned up, it's been removed, it's gone. So, to me, the railings remain here as a bit of a safety issue. I know that legal and bylaw staff have been working with Mr. DeBono, but to me, I would have really liked to see us land at a different ending here. To me, it's a beautiful upgrade to the building. It contributes to the tourism and economic development. And again, I know it's not a priority of our staff to be hindering small business, but that is what has happened here. And I really would have liked to see some leniency until a new policy either could have been developed or we could have landed on a renewal of the agreement. Again, if council could not have been kept in the loop or consulted, I would have really preferred to see staff be consulted, because I think that Mr. Cridland would have been able to say, hey, this sounds familiar. I worked on that agreement in 2012, and maybe we could have landed on just a simple renewal. I also wonder, was bylaw appeals not an option? This individual has another business in town that he's looking to sell and had to spend his weekend removing the patio and began cutting up the stones there to remove that the ground that he's laid. And then in closing, I'd just like to say, I think it isn't really rocket science to me that Norfolk County could definitely benefit from renting and earning some income on a piece of land that we're not using and could not be using. So in that situation, why wouldn't we? So I'd like to put a couple motions on the floor, but I'll let you know what they are, and then I'll let you discuss this and ask staff any questions. I'd like to direct staff to bring forward an encroachment agreement, which staff has identified we need something to close that loop. An encroachment agreement for businesses, including options for special events permits, leases, and seasonal permits by April of 2020. Additionally, a second motion that staff be directed to reinstate the previous lease agreement with Mr. DeBono at 201 Main Street in Port Dover and waive cost from 2016 to present because he's had to remove and will need to reinstall his patio. So thank you very much, Council, for your time, and I'll pass it over to you for any questions to me or to staff.
Mr. Cridland, did you want to maybe speak to the agreement? You were involved in the negotiation of that back in 2012?
Yes, through the Mayor to County Council, I was, and at the time it was very much a out of the box thinking, I think, for Norfolk County to legalize or have some type of lease for patio space. And at the time, I guess my only comments were, I think it was a pilot project actually for a year or two. The previous council wanted to be sure that there were no problems with this lease, and I believe it was my memory here. I think it was 1 or 2 years as a pilot, and then we formalized it into the five-year agreement. Mr. DeBono did do everything we asked at the time. There was the engineer design. There was, I believe, a survey, so it was tied down to that. He also did the Norfolk County infrastructure. I think it was $16,000 that he put the new curb in, some pavement on the road, as well as the concrete. And I guess in the 5 years that the agreement was in place, I don't think we've had any calls or complaints. I think the issue here is just that the agreement has fallen off, and that's all I can add. I didn't actually know anything about this until I read on social media the other day. So.
So, questions from councilors? Councilor Columbus.
Well, I'd like to know if there were any citizen complaints about this patio. Like, why did it come to notice
Myself
now?
as well. Paul?
So as the manager of bylaw, I guess I want to say two things. This is a very awkward situation to put your bylaw staff in because you're politicizing an item. This isn't really about the encroachment agreement. This is about the bylaw enforcement. So I would like to point that out. Secondly, I feel the need to correct the statement that staff were not consulted. That is not true. In terms of, I can't speak to our decision-making around why we chose to enforce this. I am not in a position to do that, and I do not think it's appropriate to politicize that aspect of it. What I will tell you is that the encroachment agreement expired in 2016. It was a seasonal patio only ever approved. We're in January. I spoke with Andy about this problem once I realized that we have a problem with this patio, and how that came to be was no, it was not through a complaint about that patio. There was another patio from which there was a complaint. Our bylaw officer attended, ordered them to remove their patio that was illegal. They did. And while he was there, he observed a second patio, and as good officers do, they do not try to treat one resident differently than another. And so that is how that happened. In terms of this problem, which is that the obstruction bylaw, which is for highways only, okay, so it relates to rights of way, highways, so pedestrian uses, that's what it relates to only. That obstruction bylaw has no exceptions to it. Of course, council can pass an encroachment agreement, and then you've got the encroachment agreement, which would effectively become a defense to an officially induced error in the effect, if anybody were actually charged under it when it was in force. So I did speak to Andy, and I asked him about a solution, and I said perhaps what we need to do is amend the obstruction bylaw so we don't have this problem again and create a permitting system. Mr. Grisell and I spoke about that, and it was his every intention, and is still happening. He is bringing forward a report to council in this first quarter so that we can ensure that patio and any other patio that wants a permit can be there in the summer, along with Friday the 13th, which that encroachment agreement did have specific reference to Friday the 13th. But it was April to October only for that 5-year period. So, without going into any more reasoning or rationale, I appreciate that people were upset to see a patio that I guess had been there full-time for many years, no longer there. But as is often the case, the community does not have all the information. And I was of the view that staff and I had consulted to be able to determine a good path forward, not only for Mr. DeBono's restaurant, but others. And in terms of the policy solution on a go forward, there would have been a report to council. There will still be a report to council. And in that context, we can certainly seek guidance and instruction from council as to how it would like a policy on a go forward to be established. But the history has always been seasonal patios.
Mr. Martin.
Thank you, Mayor Chop. Although it is your opinion that we should not politicize this issue, I think that's actually the job. And I bring it forward because he's in compliance now. And I bring it forward because you have identified that there is a loophole that needs to be closed through a policy. So it is the hope that we make a policy decision today. But I also believe that I'm well within my rights to update my colleagues so we can make an informed decision about this moving forward. And when I spoke to the one and only staff member who this is not pointing fingers, I was not aware that Mr. Cridlin had made the agreement myself. But when I did speak with him, he was unaware of this situation as well. And so I just think that maybe we're all very busy, but if there could have been some better communication, it may not have had to go this far, was the point that I was trying to get at, with some certain staff members not being in the loop. And to me, it seems very rational and reasonable that we would not ask a business owner to rip out an entire patio when there was a unique agreement already in the works, and that maybe council would be informed that policy decisions needed to be made on a situation like this. I hear that there was a staff report coming. I just wish that it didn't have to go this way, and I would look for more support for our small businesses.
Councillor Hoffman.
Thank you, Mayor Chop. Through you to Paula. Could you clarify, I'm just looking, there's a few different dates that I just wanted to get some clarification on. It was a seasonal patio until 2016? So, yeah.
The agreement itself, and I don't know about the pilot before that. I also, by the way, didn't realize Mr. Cridlin was involved in the agreement until I didn't receive it until yesterday. My communications were with Mr. Grisell around the existence of an encroachment agreement.
Okay.
In any event, so in 2012 to 2016, there was a formal agreement passed by bylaw for a seasonal patio, April to October, plus Friday the 13th events.
Okay.
Yeah.
So is it fair then to say that since October 2016, this patio has been, it's been illegal?
It's been in violation of the obstruction bylaw, yes.
Okay. So we have a patio that's been in violation for 3 years, and as a council, we are adding a special agenda item to a special council meeting. It's January, and I really am unclear as to what the urgency is, and I don't understand why we would need to do something like this, and I do feel uncomfortable that I feel like we have centered out our bylaw staff.
Councillor Martin.
Thank you, Mayor Chop. Paula would argue that it's always been illegal because there is no obstruction policy, first of all, not just since October. Secondly, Paula asked our bylaw staff to be here, and I have specifically noted that I respect that they have a job to do and they can only act on the policy. This is not personal, this is business. Third, this is someone's livelihood. This is someone's bread and butter, and that's why I feel there's urgency in having this conversation.
I would also like to add to that. I guess for me, why I added this to the council agenda was because today was the day I believe Mr. DeBono was finally ripping out the remainder of the concrete there and so on at a major cost to his business, only to then have a new policy to, I guess, reinstall it. I can't think of a bigger waste. And it flies in the face of everything that this council campaigned on. We campaigned on reducing red tape. We campaigned on making it easier for small businesses in Norfolk County, on making it a more welcoming community. Bylaw has been in Port Dover on many occasions since 2016, and the patio has carried on. Our bylaw operates on a complaint basis. As Mr. Columbus asked, has there been any complaints? There have been no complaints. So to me, the finding the yes in this situation would have been that Mr. DeBono had an existing agreement that needed to be renewed or extended. And that to me should have been a council decision. We have so many bylaw. I see the face. So,
Sorry.
council should. To extend the agreement. Okay, Councillor Huffman.
With respect, that agreement would have only allowed for a seasonal patio between April and October.
If council
So-
chose to change the terms of the agreement to allow it to be a full-time year-round patio to accommodate the nice structure that Mr. DeBono had built, that would have been a council decision with all due
That
respect.
it would have been. It would also not have solved our problem in an appropriate way, from my perspective as your council. And
Businesses in Port Dover operate on a seasonal basis. It is tough making, it's
can,
on.
Which very clearly indicates which way you would vote in this matter. So you would need to recuse yourself as chairperson.
I don't believe so.
I believe so.
We're all entitled. You don't discuss the way that you're going to vote on a matter?
Not when you're the chairperson.
Could you call the,
To get into it, I can't comment on something like this. It's up to council to decide. If you've raised a point of order, we've got a ruling from the chair that she's not out of order as the chair, and now your option is to challenge the chair, and council will vote on it.
Councillor Van Bassen?
Could I just ask the clerk, is there any motion on the floor that's been legally moved and seconded that we're actually discussing? Because if we're not, I don't know where we can go. Like, you need something to be discussing first, so there is no
Asking
motion on the
questions of
floor.
staff.
Through you, I mean, you always do technically need a motion. There's been something put forward, something's put forward with no seconder, but we did also hear a full presentation from one council member without a motion on the floor as well.
Councillor Michelli?
Thank you, Madam Mayor. I would like to give the manager of bylaw services an opportunity to speak, please.
So just to clarify, what I did, as Ms. Martin, Councillor Martin accurately says, I did decline a meeting with Councillor Martin and Mr. DeBono, and I indicated that I felt it was inappropriate for councillors to be present when speaking to an individual currently subject to enforcement, but that I was willing to have a meeting with him personally to discuss the issue. And I did reach out to him and spoke to him. He has not had an obligation and did not pull out his concrete. I just wanted to make it clear, people understand, the only thing that was removed was table chairs, and I gather the fence itself is easily removable. It's sort of a click-in, click-out system. So I indicated to him, until we have a solution, which is coming in the new year, please do not do anything else. And I just wanted to make it clear, we did not, therefore, require this individual to incur several thousands of dollars, as was, I guess, the understanding. So we certainly had initially had an idea that the concrete should come out, but once I had an opportunity to just speak with the individual, we decided that was not the best approach. So in terms of emotional, I'm happy to say I have nothing against the motion. The motion's great. I think the motion is exactly what what staff would have recommended, which is not so much, it's not my preference to see an encroachment agreement sort of stand in opposition to the bylaw. My preference and my recommendation from your lawyer is to say amend the obstruction bylaw to allow us to create a permit system or other instruments, which may include, I guess, an encroachment agreement, so that they just don't conflict in any way. And that was the proposal that we were going to bring forward to council in the new year, that because I think on the policy issue there is absolutely no disagreement, and I would certainly support Councillor Martin's recommendation that we have a motion, and anyway we're doing it, so let's get it done and resolve this issue. And one of the other points I would like to make is the permit system certainly doesn't have to be seasonal. That has been what council had chose to do in the past. There is no reason why a permit system couldn't allow for a full year use of a patio in an appropriate location. So certainly I would be prepared to work with staff on that question about if someone applies for a permit, what are our options, how do we look at it, what makes sense here versus somewhere else. And I also gather there's not actually all that many patio permissions specifically that have come forward and been requested to council. So I guess that's all. I wanted to make sure I got the facts, that people got the facts straight, and that secondly, I am actually in full support of the policy direction that Ms. Martin wishes to go in, Councillor Martin wishes to go in.
Councillor Columbus.
Yes, Madam Mayor, I realize now back in 2002 when this happened, the reason it was seasonal was there was some concern about snow removal and ice removal in that section if the patio was there, and how that would hamper snow plowing and that type of thing. And that's why I believe it was seasonal. But going back to, perhaps the clerk can answer this, should this be through a notice of motion, Mr. Clerk, or are we free to deal with it through a full-fledged motion that will be ratified on the 23rd of January?
We put it on today on the special council meeting. We're more than happy to defer it down the road. The part of the challenge was that Councillor Martin had asked for a meeting and was denied having a meeting with Mr. DeBono. And arguably, I believe that he has complied in terms of the enforcement issue. So it's no longer a bylaw enforcement issue. He ripped everything down. So that was the reason, the frustration here, to not be able to have a conversation on the basis that it's a bylaw issue, but the bylaw issue had been resolved. So that was why we put it on today, to hopefully, I mean, it's a pretty major issue against all of council, as you'll see in those notes, in Port Dover, which is a big, and it does fly in the face of what we ran on. So that was the reason for putting it on today, because it was something that was, happening as we speak, and the hope was that we could avoid any sort of further destruction of the patio. But if you want to put it on as a notice of motion for the following council meeting, that's no problem as well.
From the clerk on that, because nothing happens until January 23rd anyway, doesn't it?
No, the special council meeting would be ratified today. Councillor Taylor.
Thank you, Madam Mayor, and through you. The solution to this, though, is coming. Like that. When are we expecting that report to come forward?
So to provide some background, for the last 2.5 years, this issue has been, I've been discussing this issue with DCS. What often happens is it comes up in March or April when people start asking for patios. This past summer, through discussions with Pam Dusling, DCS decided to approve no new patios for 2019 till we sorted this out. I was in meetings in July and August with 5 people, including the general manager at the time. I'm currently the only person from those meetings that still is employed with Norfolk County. And so when Paula and I began to discuss this in October and November, I offered to take the work that they did and bring it forward. That report should have already been before you 2 months ago. It's just the staff turnovers got it delayed. That's the only reason why we're bringing it forward. And I'm doing the work in February. And it will be, we want to get it done in February because we want to have these applications that start coming in March and April done. And there is an application process even for the temporary one that currently exists, there's a form, and we didn't get that form from Mr. DeBono. So there is currently an application process, but we want to amend it and correct it.
Okay,
Councilor Shelley. Oh, sorry, Councilor.
I know there's a presentation coming next week regarding some patios in downtown, so I do want to make sure that we're underway for all that and everything too. So,
Councilor Shelley, then Councilor Martin, then Councilor Hoffman.
Thank you, Madam Mayor. Through you to the clerk. Andy, the report you're referring to, will it intend to address all of those other peripheral issues regarding outdoor patios, especially the bump-out patios? There was a lot of misinformation, I believe, last summer, and I know you are correct that we decided as a result of that to not grant anyone any particular type of patio permit. So I'm hoping that that report will clarify and make clear what people are allowed to do and what they're not allowed to do.
Through you, Mayor Chop. Yes, I think what we determined would be a preferable option is requiring all locations to post a notice of their intent of an application for a patio so that anybody can comment, and to also ensure that the ward councillor is included in all that correspondence so that before anything is entered into by the county, you have kind of a full picture and people have the right to comment. It'll be up to council to decide if you want to approve every single one. That could be a bit time consuming, especially with the ones that we have in Simcoe, as there's been a pilot project here that hasn't had contracts or anything like that. So part of this issue is to get something in place that works for Simcoe and other areas as well.
Thank you, Andy. That sounds good.
Councilor Martin.
Thank you, Mayor Chop. My initial concerns, firstly, with the report coming forward, was that there would be a delay and that we'd be into March, which was Friday the 13th for this business owner. And now as we sit around the table here, I'm actually kind of shocked at some of the lack of support. It doesn't feel like it should be this hard for me. There was a council of the day that sat around this table and made a unique agreement. I would really like to see that agreement reinstated until there is some type of renewed, updated policy for this business owner. I would like to see his patio back up, and I would like to support staff on their endeavors through new policy in the future, and that's really all it boils down to for me.
Councilor Hoffman.
Thank you, Mayor Chop. Through you to Paula. Another question in regards to since 2016, when the lease agreement was done, what could the business owner have done from that time to this time? So almost a 4-year time period. What could they have done?
So I'm going to defer that to Andy because that would have been within his purview, not mine.
So, I mean, there's two different aspects. I mean, you could have applied for a permanent encroachment, which would have come forward to council through a more formal process. Bylaw would have been registered on title. The temporary seasonal one has an application process. So prior to the expiry in 2016, we were in communication, Mr. Cridlin and myself were in communication with Mr. DeBono, and we did notify him of the need to come in and file a new application to get it extended. And so I've been raising several times over the last couple of years, I've been raising that there was an outstanding enforcement issue because it is a liability issue for the county. I wasn't involved. I don't direct bylaw staff or anything like that, but it has been an ongoing issue for a number of years that the last two GMs prior to our county solicitor have been advised of.
Okay, so thank you for that clarification. So there was definitely an onus on the business owner that they were aware that it ended and that they've had almost 4 years to get something else in place. Thank you.
Was he notified of this, Andy? When?
There was some interpretation around the contract when it was expiring upon the exact expiry date of it. Because of the date that council approved it and the date that the contract was actually assigned. And so when I was involved with it with Mr. Cridlin, we agreed to take a broad interpretation of it to grant him an extra year, and I believe it was in 2016, to allow him to participate in the Friday the 13th at April, and that happened in February or March of that year. So we said to him that you could have the duration of that year, although it was supposed to be a time-limited contract, and we took a broad interpretation of the contract, and at that time, through those discussions, we advised him of the requirements to do it, and I was kind of adamant that it needed to be done in February or March because we get these things late and we have to bring the report to council. And so when we get the application in April, it's really tough to get something set up.
Councilor Martin.
Thank you, Mayor Chop. We have a business owner here today that would like to renew his lease or buy the land. Norfolk County is in a position where we should be making money off of pretty well anything. Where that broke, it is space that we cannot use. I'd like to see a small business take advantage of that and hold up his end of a new agreement. I'd like to put a motion on the floor that staff be directed to reinstate the previous lease agreement with Mr. DeBono at 201 Main Street in Port Dover, and that staff be directed to, and that I'll separate the second one into a second policy motion.
Did you want to extend that? I think one of the corrections was that it be on a year-long basis.
Thank you. For an annual basis.
Thank you, Madam Mayor. Question for staff. If the business owner has a lease on that portion of property, then it's no longer obstructing the roadway or the highway. That solves all the problem, right? As long as he leases it, that's different than an encroachment agreement, which is different than a permit to bump out onto the sidewalk?
So I think it would be very unusual to put a lease on what amounts to a highway under our rules. I think and I thank Councillor Columbus for pointing this out, there is a concern with clearing sidewalks and other activities through the winter. Obviously, we don't have a lot of snow at the moment, but that was probably the issue, and it is our property. So I would not recommend a lease. I don't even think I recommend an encroachment agreement. I think as a strategy, it is a poor strategy to deal with this issue. But you have my advice on that, and you will choose to do what you will choose to do. If the council would like to put in an encroachment agreement, which could be amended to reflect an annual requirement, like permission for annual, you can do that. I would request that it become null and void in the moment that we have a new system in place, which will probably be in 2 months. But to be honest, it is a seasonal business, as was indicated. I am not aware that this patio was of any significance or importance during this period, but in any event, that's not my business. What's my business solely is understanding the legal situation for the corporation. So not a lease, and even if there was a lease, I don't think that would satisfy the problem of snow clearing and other concerns that we might have with having patios year-round.
I just have a question about the snow clearing that we keep coming to. Who is going to clear the snow there now then? So if Mr. DeBono's been clearing the snow where that patio is, if now is Norfolk County have plans in place then to clear the snow?
It's a fair question. The problem is I don't know. I have not had an opportunity to actually carefully look at it to understand the situation to know.
Well, I think up until now, he's been clearing the snow, but as of tomorrow, if I were Mr. DeBono, I wouldn't be clearing the snow.
Yeah,
Madam Mayor,
I just don't know.
we have a bylaw in place that adjoining property owners are forced to clear county property of the sidewalks in front of their homes?
That is true.
So, you can't have it both ways here. We're going to force you to clean our snow, but we don't want to let you take care of that snow yourself because we're not going to lease it to you, right? How does that make sense, anybody?
This is my lack of...
And yes, it is rather unusual to lease a portion of a highway under the definition of the Highway Traffic Act definition, but I didn't ask if it was unusual, I asked if it's possible.
And honestly, I wouldn't know if it's possible. What I would know is that it's not generally done. So I think an encroachment agreement serves your purpose. I don't think we need to go into the question of a formal lease, right?
Councillor Rabbits, I saw you had your hand up.
Thank you, Madam Mayor, and through you. I'm struggling a little bit to find the right answer here. It sounds like there's a little bit of nuance that might be best served in a staff report. We have one coming in the future. I also struggle that when we have an issue come before this council, we have an opportunity for an advocate or council serves as a community champion and sort of lays out the problem to us so we can understand it. We'll have a staff member sort of present their interpretation. Mr. DeBono is present here today, and if he would like, I would like to hear from the property owner. I can tell just by the images of the before and the after that Mr. DeBono, Southside Louis, I can tell he takes real pride in his business. He's done a remarkable job of improving that corner and that business and adding a lot of value to that corner in downtown Port Dover, in addition to the patio that has since been removed. And I feel that as a community councillor that I would need to hear from the individual directly. Often we receive a lot of correspondence through our email. Folks are under the impression that they can contact their councillor or maybe improve their situation without appearing before us in the public eye. I think it's very important for those watching at home and for the entire community to get all the facts, just as much as it's important for us to understand all of the facts. And if there's been some correspondence that I haven't been included in, or the public has not received as information, it's an opportunity for us to hear from Mr. DeBono directly and sort of hear, I guess, the other side of the story. I appreciate it puts our bylaw department in an awkward position, but in the same breath, it puts everyone in an awkward position when we don't have all the facts and we don't hear both perspectives on an issue. So with that, I realize that we're running short in our special meeting and we're about to open our public hearings committee. At this point in time, I would hope for either a deferral or if we can provide an opportunity for Mr. DeBono to have just, his 5 minutes at the microphone just to sort of describe the other side.
Okay, did you want to put that motion on the floor then for Mr. DeBono for a couple minutes?
I would.
Okay, and then is there a seconder? We'll need 2/3 majority. All those in favor? And that's carried.
Anyways, thank you. I would like to see a yearly permit for our patio because I did pay for all the sidewalk and install everything, and it is used year-round. So my patio doesn't really encroach on a highway because it is Clinton Street, which is a side street, not Main Street. My patio doesn't encroach on Main Street at all. It is a side street that isn't nearly used as much as a main street of the highway. So I would like to have a yearly encroachment agreement or purchase this piece of property, but it's obviously we'll have to carry it forward at another time to get all the facts and laws in place. Thank you for your time. What else to say?
I guess, can you
Any
just maybe
questions?
touch on, just for council, how much sort of the work that you went through and how much money you invested to be able to put the patio there?
Yes, yeah, we did have all drawings engineered and architectured from the center line so that it wouldn't be encroaching on the sidewalk. So it was all measured and legally done back in the day, and I did pay for it all for my business, and we actually put in extra washrooms to accommodate for the capacity of the patio all year round. So I would like to have the agreement be all year round rather than just seasonal. And it doesn't really doesn't hurt the sidewalk. It isn't on the sidewalk, it's on a piece of land that never gets used.
I think the sidewalk's actually wider there than
Yes,
it is
it's-
further down
yes.
the street. Any questions from councilors? Councilor Rabbits, any questions or anything?
Yes, thank you, and through you, thank you, Mr. DeBono, for taking time out of your day to come on down here and appear before us in the public eye and the cameras and sort of give your take on the situation.
And
I was hoping to ask you about the urgency to the matter? Because
Well, we have a Friday the 13th coming up in March, and in 2016, my business was closed and the main street was all ripped up, so we didn't have any Friday the 13th in 2016, and my business was closed from March 8th to October 12th of 2016. It wasn't open at all. So we did not use the patio that year, and the other 2 years after that, Main Street intersection up at Angelo's and most of Main Street and over the lift bridge were also closed in 17 and 18. So we didn't really deal with the situation until the road work was all finished, which is now it's coming to a new agreement.
Thank you for that.
Okay,
Thank you, sir.
thank you.
Oh,
Louis, one sec.
Louis, sorry, one more. Councillor Taylor.
Having heard that in about 2 months, there's not going to be a need for an encroachment agreement at all because the new policy will encompass that. By the time that this is all sorted out, we're going to have the new policy in front of us
Yes,
anyway.
we don't need a new encroachment agreement right now, but I would like to have it for March
But
12th and
we're
13th, which is coming
not
up.
going to need it by that time. Are we going to have the agreement in front of us before next Friday the 13th?
Certainly, hearing what council's saying, there is a policy that will have, hopefully, at least a period of public notification. I'm hoping that we could also put in any report that the public notification around this specific patio, to the public, if you have concerns about this patio, please write to the clerk's office, and then we won't have to go through that phase in the process. Council could exempt that process in February and have an encroachment agreement entered before March.
If I may, I just want to clarify, it may or may not be an actual encroachment agreement. It may be a new permitting process, same result.
Yes. And thank you, by the way, for calling me yesterday before I smashed up my patio. Okay, thank you.
Okay. Councillor Martin, you had 2 motions on the floor, or 1 motion? Did you want to repeat your motion then for council? Sure.
My motion is that staff be directed to reinstate the previous lease agreement with Mr. DeBono at 201 Main Street in Port Dover until such time as a new policy is updated and amended. Reinstate an annual lease agreement with Mr. DeBono until such time as policy is updated and amended by this council.
Is there a seconder? Councillor Rabbits. Any further discussion? Can I get a recorded vote, Andy?
Councillor Geisens. Councillor Rabbits.
Yes.
Councillor Columbus.
Yes.
Councillor Martin.
Yes.
Councillor Van Passen.
No. She did make the correction before when she said on an annual basis. She just didn't read it, the correction this time. The motion was read correctly the first time. Can we restart the vote then based
Can
on
I-
the basis that it was made with the correction?
I just want to clarify the technical language rather than lease encroachment agreement. That's all. The motion read lease, I think.
As long as the motion is achieving the result that we're asking for.
A year-round.
Perhaps enter an encroachment agreement rather than
Year-round.
reinstate.
Okay, so let's start again.
That staff be directed to enter an encroachment agreement with Mr. DeBono at 201 Main Street on an annual basis until such time as the policy is updated and amended. Councillor Geisens. Councillor Rabbits.
Yes.
Councillor Columbus. Councillor Martin.
Yes.
Councillor Van Passen.
Yes.
Councillor Huffman.
No.
Councillor Michelli. Councillor Taylor.
Yes.
Mayor Chop.
Yes.
The motion carries.
Okay, Councillor Martin.
Thank you, Mayor Chop. I'd like to put one more motion on the floor that staff be directed to bring forward I'm looking at you, Paula. An encroachment agreement for businesses, including options for special event permises, leases, seasonal and annual permits by April of 2020?
So two things. No, we want to do it sooner than that. We're aiming for February, but it's not going to be, I think it's not going to be on encroachment agreements specifically. A better direction would just be a policy framework with necessary amendments to the obstruction bylaw by February.
Okay, so I do not need to include and further that amendments of the instruction bylaw come forward? Wrap it into one?
I think so, yeah.
You got that okay, Andy? Thank you.
Councillor Huffman?
Just a question to Paula. So at this point then, after that vote, would Mr. DeBono's business at Southside Louis be the only patio in Norfolk County that has an annual patio license?
I guess that's right. I had requested earlier that his encroachment agreement expire. We can add a clause, if it's acceptable to council, that it expire in the moment that a new permit is put into place through the new system, so that there isn't an interruption.
Okay, is there a seconder for that motion? Okay,
The language is right on that, getting it in February, and we have the language down now. Okay, I'll second that.
okay. And can we get a recorded vote again, Andy?
All right, Councillor Taylor,
Yes.
Councillor Michele,
Yes.
Councillor Huffman,
Yes.
Councillor Van Passen,
Yes.
Councillor Martin,
Yes.
Councillor Columbus,
Yes.
Councillor Rabbits,
Yes.
Councillor Geisens,
Yes.
Mayor Chop.
Yes.
Motion carries unanimously.
Thanks. Okay, so I guess that's all. We'll adjourn our special council meeting. Can I have a motion for the confirming bylaw? Moved by Councillor Rabbit, seconded by Councillor Van Passen. All those in favor? I need some hands. All those in favor of confirming bylaw? That's carried. And a motion to adjourn. Councillor Martin, seconded by Councillor Huffman. All those in favor? And that's carried. We'll start the public hearings at 3:15.
On a strip of sandy soil lies a county called Norfolk. It's Ontario, south coast, you know, and it's surely not remote. If you pass through or spend a day or decide to call it home, you'll see why we love it here and are proud to call it our own. Norfolk, Norfolk, a southern county home. Norfolk, Norfolk, we know you can't go wrong with the friendly folk of Norfolk. You won't be a stranger long. Take in the small town atmosphere, be amazed at all that we grow. Like our kids that go and see the world and can't wait to return home. Drop a line in a placid lake or stroll along the shore. Take a tour on a peaceful country road and bound to be back for more. Of Norfolk, Norfolk, my southern county home. Norfolk, Norfolk, we know you can't go wrong with the friendly folk of Norfolk. You won't be a stranger long. With hard work we built a dream that only willing hands could do. It's on display at our fall fairs and at all the festivals too. Erie beaches, Carolinian forests, where the flower and dogwoods bloom. Patchwork fields and rolling hills, it's just the place for you. Norfolk, Norfolk, a southern county home. Norfolk, Norfolk, we know you can't go wrong with the friendly folk of Norfolk. You won't be a stranger long. Norfolk, 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 you won't be a stranger long. On a strip of sandy soil lies a county called Norfolk. It's Ontario, south coast, you know, and it's surely not remote. If you pass through or spend a day or decide to call it home, you'll see why we love it here and are proud to call it our own. Norfolk, Norfolk, a southern county home. Norfolk, Norfolk, we know you can't go wrong with the friendly folk of Norfolk. You won't be a stranger long. Take in the small town atmosphere, be amazed at all that we grow. Like our kids that go and see the world and can't wait to return home. Drop a line in a placid lake or stroll along the shore. Take a tour on a peaceful country road.
Okay, welcome back, everyone. Good afternoon and welcome to the Public Hearing Committee meeting for January 7th, 2020. I would like to remind everyone that our meetings are web streamed and televised, and for those in attendance, I would ask that you ensure your phones are on silent mode. Thank you, as always, to our camera volunteer, Mr. Jackson, who's with us again this afternoon. To begin with, are there any declarations of pecuniary interest? Okay, seeing none, are there any changes to today's agenda? Do you have the motion sheet there for me? Great. If I can have a motion to move the agenda as presented, moved by Councillor Martin, seconded by Councillor Rabbits. All those in favor? And that's carried. I now officially open the public meeting held under the Municipal Act and the Planning Act for the purpose of hearing applications and proposals and affording any persons in attendance the opportunity to make representation to the Public Hearing Committee. A reminder to those coming forward to address the Public Hearing Committee to please state your full name and address when you come to the podium. Those speaking on planning matters, please be advised that to preserve your right to appeal to the local planning appeals tribunal, you are required to make comments or provide written submissions prior to the passage of a bylaw. A reminder that we have new rules in place around public hearings, so we will be limiting speakers to 5 minutes unless they are the applicant or planner, in which case we will provide some leeway to present their applications. Speakers, please also be reminded that information presented cannot be repetitive in nature. The first report before us is Staff Report DCS 20-16. Application has been received to extend a temporary use bylaw to permit the use of a garden suite for a period of 3 years upon the subject lands. Rhonda Vanderven has put forth the application affecting the lands described as 275 Norfolk County Road 13. And I guess, Alicia, is that you? As staff could present, please.
The purpose of this application is to extend the use of an existing garden suite for an additional 3 years. The lands are designated and zoned agricultural, and no comments were received from the public, and no concerns were raised by circulated departments and agencies. This application is consistent with the provincial policy statement and conforms the intent of the official plan. Staff support this application and recommend that it be approved.
Questions from the committee for staff? And my microphone wasn't on, my apologies. So that was carried unanimously. Next report is Staff Report DCS 20-03, an application that's been received to amend the official plan and zoning bylaw to permit a residential apartment on the main floor of the existing building without commercial space. Christopher Coates and Agent Civic Planning Solutions have put forth the application affecting the lands described as 76 Alice Street. Is that you, Mr. Vaughn, or Alicia? Okay.
The purpose of this application is to permit a sole residential use on the subject lands without any commercial space. The lands are designated downtown in Zone Central Business District. No public comments were received, and no concerns were raised by departments or agencies that were circulated. This application is consistent with the provincial policy statement and conforms to the intent of the official plan. Staff support this application and recommend that it be approved.
Any questions from the hearing committee? Mr. Rowe, did you wish to speak to the application? Does the agent or applicant wish to speak? Any questions from the committee? Okay, is there anyone that wishes to speak in favor of the application? Does anyone wish to speak in general or in opposition to the application? Somebody wish to move the staff recommendation? Councillor Huffman, seconded by Councillor Taylor. Any further discussion? All those in favor? And that's carried. Third one is Staff Report DCS 20-04. That's an application that's been received to permit a minimum lot area of 28.06 hectares in the agricultural zone where 40 hectares is required. Special provision 14.303 is also proposed to be removed from the retained lands. Burning Kiln Winery Partnership and Agent Elder Plans Incorporated have put forth the application affecting the lands described as 1725 Front Road, and staff could present.
The purpose of this application is to permit a lot area of 28.06 hectares where 40 hectares is required. This is required as a condition of a previously approved consent application. The lands are designated and zoned agricultural, and no public comments were received and no concerns were raised by departments or agencies that were circulated. This application is consistent with the provincial policy statement and conforms to the intent of the official plan. Staff support this application and recommend that it be approved.
Any questions from the public hearing committee? Does the agent or applicant wish to speak?
I was contacted a couple of times by a lady that lives in a residential lot that this farm parcel encircles. Her questions were not about the size of the lot, but that I had left it out, and I promised that I would mention it at the public meeting. So that has been carried out. Basically, the Alcohol and Gaming Commission requires that a certain amount of Vineland be on the lands with burning kiln, and so that's what the previous boundary adjustment was. So this is just the retained lands, which were only 34 hectares in the first place, and we're reducing them just down to 28. So still very viable and meeting policy, as staff has said. Thank you.
Thanks, Mary. Any questions from the Public Hearing Committee? Okay, thanks. Does anyone else wish to speak in favor of the application? Does anyone wish to speak in general or in opposition?
Hi, I'm Murray Braun. I own the residential lot that's surrounded by the proposed abutment. There are a few other things that were kind of missing on the paperwork that I received from council. One being the size and dimensions, the specifics of the barn that's on the property. It's, I think, about 10 feet away from one of my buildings. And I know that some of the inner wood has been removed in the last year to make it into a one-level interior. It is an old-fashioned hip roof barn, and it is starting to progress off of the foundation towards my new building. The other thing is that I don't know exactly what she said about the size of the property beginning, but it was originally, and it does say in the application from Frank and Christine Liebeck, they originally purchased that property from my family, and the original size is my question, because all of the property originally that extended from the front road back went all the way up to the previous property of Frank Liebeck, and that now has been adjusted somewhat. I don't know if that was done here. I never got information about that back property line being adjusted. But I'm just querying that if they do this now, if they decide they want to plant more vines, will they be able to come back and ask council to make another adjustment to make it bigger? If that's the case, then they should have actually done that now. So would this limit them in the future for coming back and wanting to increase the property there?
Now, did we get your name and address for the record?
Mirei, M-I-R-E-I-L-L-E, Braun, B-R-A-U-N, at 1761 Front Road.
Thanks. Councillor Taylor. Well, we can ask staff afterwards if that's what you're looking to do. Oh, Councillor Taylor wants you to clarify your questions for you.
So, one is just a statement to say that I am the property that was missed on the application when it says what are the uses of the property abutting, and they talked about the burning kill and the zip lines and farmland, but I'm surrounded now by the Burning Kill Winery zone, and as the person that's selling the property to the Burning Kill because of a retirement, I understand. Why didn't they buy more? Because there is more land there that they could buy at this point in time. And if they don't do it now, will that be an issue again that we have to come before council, or is it will it be limited to then being just that much and not being able to buy more?
Thanks for coming. Does anyone else wish to speak in general or in opposition to the application? No? Okay. Are there any further questions from the Public Hearing Committee? Councillor Taylor.
Thank you, Mayor Chop, and through you. Would this limit their ability to buy more land in the future? Just to get that out of the way.
Through the mayor, they already own the land, so it's not really affected by this application. So, and planning doesn't really affect what people can and can't buy.
Thank you. One other thing, we did receive a comment now, so if the recommendation could reflect that.
Any further questions from councilors? Okay, does somebody wish to move the staff recommendation? Councilor Columbus, seconded by Councilor Rabbits. Any further discussion? All those in favor? And that's carried. Next report, I'm assuming this is why everybody's here. Staff report DCS 20-13, application that's been received to rezone the subject lands from development zone to urban residential type R1A. The application has come forward, sorry, I was one ahead of myself, to fulfill the conditional approval of 2 severed lots off the property. And Ian and Susie Anderson have put forth the application affecting the lands described as 121 Wolven Street. Staff to present.
The application has been submitted to facilitate the severance of 2 lots that have already been approved, provisional consent from the Committee of Adjustment. As a condition of approval, they have to rezone the property from Development D to residential R1A. And the zoning will also affect the retained lands to allow the construction of a dwelling on the retained lands also fronting on Wolven Street. The bylaw also addresses the property in the rear, which is also designated for residential development in the hamlet of Port Rowan. And there's a holding category put on that pending an application for plan of subdivision in the future. The recommendation is for approval. Property conforms, or the zoning conforms with the Norfolk County official plan and the provincial policy statement.
Thank you, sir. Any questions from the committee? Okay, does the applicant or agent wish to speak? Any questions from councilors? Okay, does anyone else wish to speak in favor of the application? Does anyone wish to speak in general or in opposition to the application? Does council wish to move the staff recommendation? Councilor Michelli, seconded by Councilor Huffman. Any further discussion? All those in favor? That's carried. Next is staff report DCS 20-19. This is a subsequent report to the deferred staff report DCS 19-130 on December 10th. This is a housekeeping amendment that applies to all of Norfolk County. It is meant to increase the accessory building height in the resort residential zone and agricultural zone, amend the attached garage definition, amend the apartment unit provision in the service commercial zone, and amend the general provision regarding backyard deck extensions. And if staff could present.
Thank you very much. A zoning bylaw amendment is proposed to update the Norfolk County zoning bylaw to increase the accessory building height in the resort residential zone and agricultural zone, to amend the attached garage definition, amend the apartment unit provisions in the service commercial zone, and amend the general provision regarding backyard deck extensions. The proposed amendments are consistent with the PPS and conform to the Norfolk County official plan, and staff recommend approval.
Thanks, Matt. Any questions from the committee? Councilor Rabbits.
Thank you, Madam Mayor. Through you to Matt. Thank you for this report, Matt. I'm looking at page 5 of 7 of the report, and we have an excerpt provided from our current bylaw 3.2. It states that no building or structure which is accessory to any permitted residential use in any zone shall exceed a building height of 5 meters. An urban residential resort residential zone is 6 meters. Am I to understand that the 5 meters would be increased to 7, and the 6 meters would be increased to 8 if this recommendation was approved?
Through the mayor, that's correct. In those particular zones.
Any other questions? Councilor Rabbits, is that it? Or okay. Any other questions from the committee? Councilor Van Passen.
Thank you, Madam Mayor. On page 5 of 7, the attached garage definition, if you have a detached garage and you build roof, like a breezeway over top. Does that make it now an attached garage, or is that what we're trying to get away from?
Through the mayor, that is correct. That's what we're trying to get away from. In the past, some people have just attached 2x4s with the idea that it's now an attached garage. So with this clarification, it makes things much more clear for staff to interpret the zoning bylaw.
Thank you.
Any further questions? Does anyone from the public wish to speak to the amendment? Somebody wish to move the staff recommendation or propose an alternative? Councillor Rabbit, seconded by Councillor Geisens. Any further discussion? All those in favor? Carried. And now next is staff report DCS 20-12. This is a subsequent report to the deferred staff report DCS 19-118 on December 10th. It's an application that's been received to change the zoning of the subject lands from urban residential type 1 R1A holding to urban residential type 4 R4 to permit the development of approximately 136 group townhouse units, a stormwater management pond, parkland pathway, and internal street network. A special provision is proposed to limit the height of units to 1 story where adjacent to existing dwellings on College Avenue and to reduce the minimum lot frontage. MDR Development Incorporated, on behalf of Cindy Gates and agent Eldon Darvison, have put forth the application affecting the lands described as Price Street. And if staff could please present.
So this application was presented last month, so I won't go through the same presentation again, but I did include in my amended report responses to the questions of the committee. I'm happy to answer any questions, and nothing else has changed with the application, and staff are recommending approval still.
Questions from councillors? Councillor Rabbit.
Thank you, Madam Mayor. Through you to Alicia. Alicia, thank you for your report here. I'm looking at page 2 of 21 of the report. We have a couple figures provided about potential configurations for how dense the development could be based on the zoning provision. R1A, 72 units. It increases all the way through R1, R2, R3. Then when we get to R4 designation, we do have acknowledgement that it wasn't configured for a maximum density, and we only have a figure of what was proposed. And I would like to know, for our benefit, for the public's benefit, exactly how dense that could be. You might not have that information available, but I would even appreciate maybe a ballpark. Like, we're talking about over 250 units potentially with an R4 designation. Am I correct in that assumption?
Through the mayor, so I worked with GIS and we came up with the R1 to R3 potential number of units. It's unlikely that those configurations would ever be used just because they're not, I think, very aesthetically pleasing. Like, I don't think a developer would generally use those, but we wanted to see how many we could kind of maximum fit on there. But it would be assumed it's probably more than the R3 zone. So yeah, more than 224 most likely. But what is being presented to us is the 136, and that allows for space, additional, I don't know, there's more roads than what we put into the other one, maybe a bigger storm pond, that kind of thing. So it's more realistic that it'd be the 136. And they have a pretty good concept, so we're confident that's what they would bring forward.
Councillor Columbus.
Yes, Madam Clerk, Madam Mayor, thank you. Alicia, just to clarify, this is a condo development, so all garbage pickup, snow removal off the street, overhead street lighting, and fire hydrants are all the responsibility of the developer? Is that correct?
Through the mayor, that is correct.
Thank you.
Councillor Shelley.
Thank you, Madam Mayor. Through you to staff. Alicia, on a project like this, if it were to be approved, would there be an opportunity for public input on the site planning stage of this project?
Through the mayor, so the site plan process is open to the public. It's not circulated to neighbors. There's no yellow sign or anything like that, since it's more of a technical exercise and none of that's required by the Planning Act. But if the public wanted to be involved, they could. I mean, we have all of their comments at this stage, but they could become more involved if they wanted to, yes.
Thank you, Alicia. So basically, if in the interim period of time, if someone, a member of the public, had some suggestions or they had some ideas for possible changes to certain aspects of this plan, would it be incumbent on them to get in touch with you, or will there be advertised opportunities for them to make that inquiry?
Through the mayor, I would suggest they should contact me, and I can make a list so that when the site plan is received, we can follow up with them.
Thank you, Alicia. And also, and Madam Mayor, if I may additionally, correspondence from residents just about some of the parts of the report, and I do, while I'm mentioning that, I do want to commend you and staff on the thoroughness of this report and the very logical explanations that you have come up with to answer the questions that we had you, prepare this report for. But I do want to ask about the traffic study that was done. A lot of residents are concerned about the volume and perhaps the speed of traffic in that particular area. Would it be possible, I suppose I'm asking, for another traffic study to be done perhaps on a weekend date in the middle of the summertime to maybe possibly get another perspective on the traffic? I'm told that the actual traffic study was done on a weekday in the early part of June, which may not be what we would consider to be the peak season in Port Rowan.
Through the mayor, council could request a peer review or could request another traffic study, but it was completed by professional engineers, so we trust them that they're doing the most appropriate or taking the most appropriate approach, but it's up to council if you wanted to request that.
Thank you, Alicia. And if council were to choose that path, would that require an additional cost that council would have to be responsible for?
Through the mayor, I think it's up to you, I think, if you wanted to pay for it or if you wanted to ask the developer to pay for that.
I would think that it's within your right, Councilor Rochelle. It's a negotiation. If that's something you wanted to ask for, they would be responsible.
Thank you, Madam Mayor. And one further question, if I may. We've had in the report, Alicia, that there is adequate water capacity for a development like this. I guess my question would be, since the time between now and the actual use of that water capacity could be 2, 3, 4 years from now, will there be a plan by the planning department to ensure that in the interim place of time that we are cognizant of the fact that there might be some other requirements or strains on the water capacity that we'll have to allow for?
Through the mayor, yes. I don't believe the capacity is actually committed until the site plan stage, but yeah, I think Public Works actually maintains that information, so it would be tracked somehow, yes.
And so just to be clear, Alicia, so this would be something that Public Works would be informing the people while the site plan work is going on, is that right?
Through the mayor, would they be informing them? Sorry, I don't understand the question.
Sorry. My concern is that I just want to make sure that sometimes, and with respect, that there isn't some kind of either duplication or assumption on one hand that something is being looked at while on the other hand, they think the other person is responsible for it. I just want to make sure that is definitely going to be a part of this process.
Through the mayor, yes. So the site plan will be circulated to actually development engineering, not Public Works, so it'll be looked at again at that time. So let's say they didn't come forward for 3 years, all the capacity was used up, they wouldn't be able to build then.
Okay, thank you, Alicia. And Madam Mayor, that's all my questions for now, but I will have another one later.
So just while you're on the water capacity issue, Councilor Michelle, I did write to Mr. Godby following the information package on December 17th that Alicia had her follow-up in and had the amount of cubic meters available in capacity for the water and sanitary, but I was more curious as to how many homes that would be remaining that we would be able to use. So what that worked out to from Jason Godby when he put it on a maximum per capita day demand in Port Rowan, what would remain after these 136 units would be the capacity to support an additional 73 people on our current supply, so without any further upgrades. So that's another 30 homes. So basically, there would have to be further upgrades before any further development was done after this. Councillor Martin.
Thank you, Mayor Chop. Through you to Alicia. I wondered if you could circle back to the traffic study comment. I don't have a lot of experience with traffic studies, but anything that I have reviewed from development and considerations given in Port Dover, they were typically more than a day worth of studying. Is that the case with this study? I know quite often developments might have a traffic study done for 3 days, varying times, and data is collected in that study.
Through the mayor, I would have to look back at the study and get back to you with that answer.
I could just jump back in. Councillor Michelle, you were asking about the site plan as well, and one of the things I've looked into some other areas too, and I think would be possible here, you know, we've already taken a new approach with planning matters of moving up the public hearings and trying to get input before we made a decision and so on and so forth, so it's not all happening at the same time, would be that council has the final approval on the site plan for a major development. And that way we could determine whether we liked the plan. So that might be something to consider adding to the motion, that council would be would have the final approval.
Thank you, Madam Mayor.
Further questions from councillors? Okay, does the agent wish to speak?
Thank you, Your Worship and members of council. My name is John Valley, and I'm here with our client, Mark Segal, and Richard Kim. We just want to say we're really happy with the staff report that came forward. We think it addresses all the concerns and questions from council. I did want to touch very briefly on the idea of extending Price Street across this development. We know that that's something that was not supported by the staff. It's not really something our client was interested in doing. We do note that it would be extended to get access to lands that are not within the urban boundary now. We've taken a look at those lands and the existing vacant lands in Port Rowan that are already designated for residential development. As the mayor already alluded to, there need to be a major expansion of both your sewage plant and your water plant in order to be able to service these lands. So you have much more land in Port Rowan already designated for residential development than you can support. So we don't see any long-term expansion of the urban boundary in that direction, especially since that would reduce your buffer between your existing sewage plant and the existing residential area. It's always been the practice of Norfolk County to try to keep large buffer areas around your sewage plants to buffer them from the residential development. So we just don't see that that boundary will get expanded in that direction in the long term, and therefore we're not looking at any form of expanding the road through the development. A couple of quick comments. Councillor Rabbits, you asked about densities and total numbers. My client is willing to commit to the numbers that you see, so if that's something that's of concern, we could easily have it added into the bylaw that it would be zoned for up to, I would suggest, 140 dwelling units as a maximum. You could put that right in the zoning bylaw. We're not interested in doing 200 or the numbers that were being quoted for so on. And when it comes to the concern on traffic and the date that the traffic study was done, that's just the day the actual counts were taken. We don't want to get involved in the time delays of another whole study or a peer review or these things. If council wants, through the site plan process, we could send our consultant back out there and he could get another set of counts in the summer. We could see if that has any impact at all on the results of the traffic study. I don't anticipate that it will, but if you'd like us to go out and get another sampling date, we can certainly do that, and you can simply give direction to your staff to require that through the site plan approval process. So I think that can be very easily addressed as well. Mark, did you have anything that you wanted to add? Yep, Mike. Okay, Mark Siegel, who is the developer, would just like to address council briefly as well.
For Mr. Valley, while he's here. I guess just only comment that I have is that you say that's, you know, there's not lands within the, or those lands beyond at the end of Price Street are not within the urban boundary now. And then you kind of also spoke of what's always been the practice of Norfolk County. I think that this council has suffered greatly because the past practice of Norfolk County has not been to look into the future. And I think we would be remiss if we didn't consider what could happen 20 or 30 years from now when the rest of those lands are used up. So I don't know that it's fair to say that just because those lands aren't within the urban boundary now, that in 30 years down the road, they might not be in the urban boundary then.
No, I agree. There is potential there, but when you look at the vacant lands which are residentially designated now, and if you apply a density to them that would be for single-family dwellings, you're approaching 2,000 more people would have to move into Port Rowan before you would use up the lands that are designated today. So 2,000 people moving to Port Rowan is a big number. And if there were urban boundary expansions, we just don't think it would be in that direction because it is in the interest of the municipality to maintain your buffer. The Ministry of Environment has standards in that. I don't know what those are off the top of my head, but they do want to keep, obviously, your development separated from the sewage plant so that you don't have problems with odors and all these kinds of things. So that's where we're going, is that you've got a lot of vacant land in Port Rowan today, and it's going to be a long, long time before you use it. You'd have to upgrade both your sewage plant and your water plant in order to have the capacity to service those lands. And if you did expand, we doubt if that would be where you'd go.
Long time possibly, but that's not meaning that it could never happen. It is a negotiation and you are looking for R4.
Fair enough.
All right. Any further questions from the committee? Councillor Van Passen.
Thank you, Madam Mayor. One of the proposals in here is a 20-foot pathway across. Are you proposing to give that to Norfolk County or just grant Norfolk County an easement across that?
That's something that we work out that detail with the county and staff as part of the site plan approval process. Would be sort of at the pleasure of the county.
Since you won't give me my road.
Just on that note then again, I remember that there was something in the previous report, I don't believe it said this, in terms of the parkland. Is it just straight cash in lieu for parkland, or is there an assumption that you guys are going to have some parks and Norfolk County would be responsible for it?
So under the Planning Act, as you know, the applicant is required to provide a percentage of the land or a percentage of the value to Norfolk County. Correct. So that can be done in combination. So if the walkway, for example, was to be provided as a land that was going to be deeded to the county, that would be part of the parkland dedication. Let's say, I'll make up a number, 2%. And then the 3%, because you have to have a total of 3% of cash could be provided to supplement that. So there could be, those kinds of things are worked out with community services.
Well, it's community services, but it's also council, especially as we're moving into some pretty challenging budget times. I think probably the county needs to start owning fewer things rather than more things. So acquiring additional lands might not be the smartest way to go. Councillor Huffman, did I see your hand? Any further questions? Councillor Van Passen.
Well, see, that would be my follow-up. I was going to bring up later. Then, I would be more than happy to accept 100% cash in lieu of parkland. You provide the walkway and just grant the county an easement across that 20 feet, and then we get the best of both worlds out of the deal. Is that a possible solution there?
Anything's on the table at this stage, so we'll look at that one at site plan.
Okay, thank you, Mr. Valley.
Thank you.
Mayor and Council. So just following up from our
discussion last month. I just wanted to cover a few things. But before I get to that, the road part, there will also be other opportunities to connect into that land, not just from our Price Street access. There's still some farm areas and other points. It's not a dead issue in the fullness of time to that point, but it still could be accessed for urban development, even if not through Price Street. But I also want to speak to the retirees question that you had brought up last time. So while we're targeting, that's our target demographic, we do have a range of unit types in this project, and we did that from the very beginning because we acknowledge there are more than just retirees who are interested in these homes. So we have the bungalows, which predominantly would be retirees, smaller bedroom count, main floor living. We have bungalofts, which allow for second floor bedrooms, but a primary main floor master bedroom with the idea of retirees, but also a useful form of living for anybody to have a main floor. And then we have a number of two-story townhouses, and that's actually for families. That's the purpose of that, is the expectation is those are the people who would want multiple bedrooms on the second floor, and they're predominantly put towards the west end for levels and just fitting in best into the community, but that they're there as well. So we just wanted to address that point. We are aware more than just retirees will move into this development. And the other topic was sustainability that had come up, and I guess the reason I do and my partner do what we do with townhouses and that form of development is we believe it to be more sustainable than single-family home tract subdivision development. And I don't think I brought that up, and I should have at the time, but the whole idea of townhouses is that they are much more sustainable than other forms of building, even than apartment condos and that kind of stuff, because they're small enough that they're approachable, human, walkable, those kind of words, but they're also attached, so your heating bills and environmental footprint is lower. And also they're walkable to the downtown. And we picked this particular spot because it's just a few blocks from the downtown Main Street, and no one needs a car to access those points. And there was a point brought up about the density of this site, and technically you could have made it more dense, but I wanted to see all those roads. There's a lot of internal roads, and the reason for that is pedestrian walkability. You don't have just one big long central block. You have to walk all the way around. It's got several points to cross, and that's all to promote walking and less, a smaller carbon footprint, I guess, by the users. And then finally, it's a very efficient use of the county's resources in terms of water and sewer. This is one 12-acre section with one or two pipes connecting to it by the county that services all of these people, and the maintenance for the county over time is simply those 2 points of connection. The condo will take care of the rest. Whereas if it were a subdivision of houses, single family, that would be, numerous streets and lots of future water and sewer bills to maintain that. So I think there's a lot of sustainable points in our proposal, and I just wanted a chance to present those. And of course, ask if anyone has any other questions of me.
Questions from the committee, Councillor Ross.
Thank you, Madam Mayor. Through you. My question is maybe less a question, but more of a comment. It sounds like the staff report is viewed very favorably between yourself, the agent, and the applicant here. I'm looking at page 5 of 21 of the report, and it's about sustainability and looking at sustainable options. And one thing that's a real amenity that we have is the beautiful front road and the fact that cycling is very popular. We've been designated a bicycle-friendly community here in Norfolk County. We've won awards, and I envision that this is something that we're going to continue to pursue, active modes of transportation and promoting healthy, active living. In the report, it states that the county can request bike racks, for example, to be installed, and I see in the footprint there's some spaces for parking. And if I may, I would suggest that that is something that I would think would be a nice feature to have on site, is a couple bicycle racks for those to bike into town. Perhaps it could reduce the density of the vehicles that are on the road, if we could promote other forms of transportation. And in the report it says, that the county can request this, and I would suggest that perhaps at the site plan stage that you think about putting in some bicycle racks or looking at promoting, again, the walkability of the new neighborhood that we're looking at creating.
I think it's a great idea, and although in this community arrangement where it's residential, I suspect most people will keep their bicycle in their garage or somewhere close, and then it might be the visitors who would like to use that, or which might be in visitor parking. But anything to promote additional use of bicycles, I think, is a wonderful idea. Yeah, it is a very nice thing we have here in the county.
Councillor Michelli.
Thank you, Madam Mayor. Through you to Mark, and with regard to Councillor Rabbit's questions, Mark, that's one of the reasons why I have been getting some correspondence from residents. Should this development be approved, that there are all kinds of suggestions and inputs on these types of topics that the public would like, and you should expect they will have input on, because there are a lot of good ideas out there. And I realize that, bike racks are just an example, but anything that can improve the sustainability of this development, and also, frankly, for those people who are living adjacent to this development, that they that things are done in a way that they will not be regretting their location in 10 years or 15 years. Thank you.
Yeah, I agree with that as well. There's nothing like local input on matters like that. And obviously, constructive stuff is more important, more useful than things that just want to try to not proceed of any development, just a field. But I think that's a very valuable resource, and we would be interested in that as well. And I know Madam Mayor had mentioned that the idea of bringing this to council for site plan approval, it's a good idea, but also a scary idea for me, because I don't know where that evolves to. At least with staff, there is a specific, we're meeting a certain standard and we're trying to work towards that, and we can certainly talk to staff. I get nervous when that goes up in the air and I don't really know what we're going to end up with. So I just caution that that's a great idea, but maybe giving staff instruction is a stronger long-term plan, so that we know we know the environment that we're operating in, as opposed to a very open and unknown process.
Councillor Michelli.
Thank you, Madam Mayor. Mark, I suppose that goes both ways. Coming before council does give the public a very definite opportunity to observe that process and to be part of it. So I understand business does not like uncertainty, but I do think, on the other hand, that there is a concern by people that while dealing with staff is very effective, for the public, sometimes it is a little bit of a route that's not necessarily easy to understand for the public about how to do it or who to contact. And if this eventually comes to council for approval, I think that then everything will be above board. But I certainly do understand your concern about that process and any delays or uncertainties it might create. But I do like the mayor's suggestion, nevertheless.
Yeah, just as long as you understand
Councillor Van
where that can go.
Yes, thank you, Madam Mayor. I've been trying to roll around in my head how to word a motion that could make you a little more comfortable, but still achieve a goal I'd like to see. And I'm thinking of along the lines of having you work with staff like you always have, and just throwing into the motion that it be brought back, the site plan be brought back to council for final approval, and that you basically do the nuts and bolts with staff, and then council's going to put their stamp on it at the end, and if there's some little tweaks we want to make at that time. So, and no, that's not the system we've been using in the past, but I think you've noticed that we want to change that a little bit. So you might be the guinea pig, but hopefully it'll do you some good and the public some good, and we as council and staff some good, and maybe we can make those little changes ahead of time before banging our head against the wall saying it's too late. Right? Mm-hmm.
Yes, I guess we're.
I guess my comments when you talk about sustainability, I don't think you're really hitting it on the head with what we were kind of getting at in terms of saving energy by having adjoining homes. I mean, that's been long thought of. I just It's not that I don't support the development down there, I do, and certainly we need development in Norfolk County right now, more than ever. But, you know, when I think of how special of an area it is in Port Rowan and in Long Point, this to me right now still just doesn't feel special enough down there. Like when I look online, I can read developments that are happening. Here's an example. Canada's first beyond net zero energy residential building comes to Milton. Coming soon, Canada's first carbon condominium homes. There's so much new stuff, cool stuff that's going on. I just would like to see that, especially in the Port Rowan and Long Point area that is all about the environment, have something like that incorporated and not just townhomes, but townhomes that are carbon neutral or that are, net positive or, Mr. Lennox, we've his development, even geothermal, we haven't talked about anything that you're doing in that way. Like I find that amazing in Dover Coast with them using geothermal heating. What a forward-thinking thing to do. But I'm not hearing any of that. And I think that's what we were looking for and from the sustainability perspective of things. For me, anyway. Any comments?
Well, I don't know enough about some of those things, but we're.
But you want to build in an area that's next to one of the gems of the world, a UNESCO biosphere. Like you're asking to do something. This is why, for me, this is a negotiation, and that's why I want to see the site plan come back to council. I don't think that historically in Norfolk County it has been a negotiation, and it's not to say that this council doesn't support development. We do, and we need it down there, and we want to see it, but. If there's only capacity for 73 more people, not even homes, 73 people in that area on our existing infrastructure, then we need to make our decisions very wisely with the little bit that we have, right? And so I just think there's just such an opportunity here for you to it might cost you a little bit more, and maybe your profit margin might shrink just a little bit, but to be able to do something that really fits in with the community in Port Rowan. And right now, as it stands, it's ordinary.
Yeah, it's a very scary thing you have asked me because I don't know what the cost of geothermal is. I don't know, I've heard horror stories about putting, solar panels on homes that seemed like a good plan originally, and then it ended up turning into a problem. I'd like to stick with, things that make sense and that we know will work. And I don't mind looking into all of those things because they're great ideas in terms of, long-term, what can we build with different materials? Can we build using, different materials that are more sustainable, that kind of thing. But to commit to specific things that the market may not be able to bear, I'm a little bit scared of that. It's not just me that has to answer to that. It's the lenders, it's the buyers, it's all these different people. So it gets a little bit complicated. We can only meet certain requirements. I'd love to be able to say, yes, we'll do all of this stuff. The stuff that I love to do is related to, bird habitat, because that's one of the reasons that is a good, an amazing part of the country, relating to lighting and window design that doesn't affect bird strikes or reduces bird strikes. That stuff, you don't have to ask me about that stuff. That we would be doing that anyway. I'm just a little bit. It's a forum where we have no control.
But it shouldn't be foreign to you. You know the area, right?
But I don't know geothermal, and I don't know those kinds of the latest things like that. It's builders who will build this for us. We're the developer.
But there are also tons of studies and reports and documents out there that would say, if you want to build to, this LEED standard, it's going to cost you X% more. And I'm assuming you have a well built out business plan, and it shouldn't be much to have thought about that. I just would have liked to have seen thought into some of these things, and I think that would have helped to address a lot of the concerns that we heard from the community previously. But I don't hear anything new. It's just we don't want to give up Price Street, and we're not changing anything else. Again, I support building down there. But I think it's a beautiful spot, and it would be a shame to just build something ordinary. Further questions from councilors? Okay, well, and does anyone else wish to speak in?
Just like to add two comments related to that, to the sustainability piece. I can speak to that, and you're talking about all these amazing buildings that are coming out all over the place. Our firm does a lot of fire station design, and we're proud to be what we believe to be the designers of the first net zero energy, zero carbon footprint fire station in Canada, which is located up in Coldstream, just outside of London. So that's a fabulous project, and it uses geothermal, and it uses all these things, and it has all these bells and whistles and everything. There is a significant cost that comes to that, and that municipality, which was very green forward thinking, was able to secure a lot of funding from various sources to offset those additional capital costs. So that technology, yes, we're very aware of that and so on, and Mark has the ability to put that into his project. But what we're talking about today is a zoning amendment, which does not talk to those kinds of issues. It simply talks to land use. Is it appropriate to have 136 townhouses on this site? And then the sustainability piece clearly comes when the developer decides how he wants to construct those units and how he wants to market them to the marketplace. Norfolk County at this stage, to my knowledge, doesn't have any policies on that, so it's very difficult to say that we're going to only approve if we're sustainable or not sustainable. There's all those requirements in the building code which are vastly improved from just a few years ago on sustainability pieces, and there's a new building code addendum that's current right now. So yes, we're aware of those things. Yes, we have that ability. Yes, we have that experience, and we have, in fact, been leaders in the sustainability piece and architectural design in Ontario and even Canada. But we're here today to talk about the zoning of the property,
Mr.
not
Valley,
about how we're going to design the building.
With all due respect, we are here to talk about the zoning, and you are asking for an additional 70 units over what the property is currently zoned for. Council did ask to hear on matters of sustainability in response to comments made from the public. My challenges right now are that the sustainability comments related to we're saving on heating because we're building townhouses and therefore the inside wall is not going to get as cold. So I think that the comments are fair, and this is the time, and while we can't say, okay, we're only going to give it to you for this, we do have that opportunity. It is a new council. We are doing things differently, and we are able to voice the concerns of our citizens, and those were concerns, and I don't think it was properly addressed, and I had hoped to hear more, and that's what I'm telling you.
Fair enough. With site plan control, we'll have experience before with municipalities where site plan control is finally approved by Norfolk County or on other municipalities. That does occur. What I would caution council, we know that the site plan process can be very long, 6, 7, 8, 9 months, sometimes over a year. There's a lot of back and forth between the applicant, going through planning out to agencies, comments back and forth, a lot of negotiation that goes on. What I would hate to see happen is that council, if you decide to hold the final approval card for this or any site plan approval, that you do not wait until the last minute to give final approval, that you engage through the process. What I would hate to see is my client goes and he negotiates and works with Public Works and with Environmental Services and with all these things and comes up with a plan, and 3 or 4 or 5 revisions later shows up to council and council goes, we don't like that, after we've got a buy-in from all the agencies. So I think you need to have a plan where perhaps council would become a commenting agency as it does with Public Works, Environmental Services, Development Engineering, all these other things. And if you don't do that, then my fear from the development side is that what we're going to create is a lot more red tape, and we're going to create something where the site plan approval process is going to become extremely long and very cumbersome for the developer, because he's not going to get your comments until he's satisfied everybody else, and then he's going to show up with a plan he thinks should get approved, and there's going to be some issue that you don't like, and you're going to turn him down, and he's going to go back to the drawing board. So we need to figure out how that would happen.
We would have one perhaps midway through to ensure that we're all on the same page and hear public comments on it if we so chose, and then incorporate that for the final. Great idea.
That would help, yeah,
Perfect.
as opposed to waiting to the end. Yes.
Okay, thank you.
Thank you.
Does anyone else wish to speak in favor of the application? Does anyone else wish to speak in general or in opposition to the application? Okay, we have heard your comments last time, so if we can just keep things very brief. And again, if you can state your name and address when you come to the podium.
Good afternoon. Good afternoon, Mayor and Council. My name is Colin Clark. I live at 48 Front Road, Port Rowan, but I'm here in capacity as the representative for the parish of St. John's Anglican Church, which owns the house I'm renting at 48 Front Road and the property at 46 Front Road. Those properties are directly to the south of the proposed development area. So our position is already in the official public record in the report. It's Appendix J, actually. But there were some points based on the follow-up report that I wanted to address or raise some questions about. The developer commented on the fact that the townhouses are actually sustainable development because they would create a smaller carbon footprint by virtue of having fewer units requiring heating because the townhouse is one block. But my question is, wouldn't that supposed saving and reduction of carbon footprint be then canceled out by the number of cars for the 136 houses? So, because, okay, great, you have fewer blocks of buildings being heated, but then you have at least one car for each housing unit. That's 136 more cars right in the community. So there was no discussion about the issue of light pollution. And here's where I disagree with all due respect to the developer, that I don't think you can separate how the land's going to be used from how the land will be used. Because they're saying, well, this is just about changing the zoning amendment, figure out the site plan after. And to my thinking, it's like, no, you should probably have your idea of what you want to build first and how you're going to do it, and bring that as part of the approval package. No, for me, it's like your kid coming to you and saying, I want to use the car to go to Toronto, but they're not telling you who they're going with, what the route is, and what plan they plan to come back. It's just, okay, just take it on faith and give us the keys. We'll tell you on the way to Toronto. And, there's a lot of disquieting information about that. One of our concerns is that there's a lot of talk about policy, provincial policy, Norfolk policy. And I think that what's being ignored is the ecological and social culture of Port Rowan. The mayor alluded to the fact that we are part of the UNESCO World Biosphere. And it's not that we're against development, but why do so many houses have to be added to that 12 acres of land? The note on, I think it's on page 3 of the report, comments that there's like, in comparison, the villages of Long Point Bay have about an average of 17 units per hectare. That they're proposing to put, I think it's what, 25 units in this area that's quarter the size of the villages. And I don't think like that kind of condensation or congestion is not something that people are really appreciating. How many people are going to be packed in that space? So our position is that we don't understand why does it have to be so many houses? And how do these houses address the actual needs of the community? We need affordable housing for that young families can actually afford. No one in Port Rowan is going to be able to afford any of those houses in this condominium. And we're talking about, they keep hearing about providing housing for Norfolk County. Who in Norfolk County can afford $400,000 houses? What retiree in Norfolk County? We have people who could use nursing homes right there in the villages, the people who are getting too old or too sick to live by themselves and would love to have a nursing home there. Single dwelling houses, a park, an actual park, because there's no park, contrary to what was said in the last meeting. The park that they refer to is actually the school property. It is off limits during school hours, during the school term. There's a fence and you can use it after hours, but there's no actual play area for the community children. So I think it would be very, very sad if the spirit of Port Rowan as a small farming and to some degree fishing community is just pushed aside because someone decided these townhouses are perfect, this will suit the community when it won't. So Thank you for your time.
Thank you. Next. If you guys could just be queued up and ready to go for the next person so that we can get through everyone. And also sign your name on the sheet of paper if you can, when you're done.
My name, oh, wait, I gotta push something here.
You want to just take it and set it on the corner over there, and then you can just...
My name is Veronica Harris, and I own some properties in Port Rowan. I live there as well, and I've spoken before. I just wanted to mention that ticking off all the boxes may work for the provincial plan for towns and cities and prove that it fits very nicely into the space allowed for those towns and cities. However, this is a waterfront village. We have quaint shops, odd ways of living, early closing hours for our businesses, and we have family-style priorities. To others that don't live here, they say how lucky we are and how beautiful our old churches look. They say we're in a special place with the water at our back doors and the most beautiful views. We are aware of that. We want our children to raise their children here, have them go to our safe and happy school there in town. The developer is trying to convince us that high-density condominiums is the answer to our prayers. Sometimes I think not really. There's a shortage of homes for families. The largest unit that they're offering, I think, is 1,250 square feet. I don't know of a family in Port Rowan with 2 or 3 kids that would live in 1,250 square feet and not be at each other's throats. Why is it that the outsiders always want to change what they loved about something in the beginning? We know that the lands are designated Urban Residential Zone 1 and are not intended to remain farmland forever. Maybe Zone 2, maybe Zone 3, but not Zone 4, and then size down even more. Not here in this village. It's like putting a square peg in a round hole. It doesn't fit. We've devoted our lives to this place, worked and raised our families here, been paying our taxes here for many of our lives, for a lot of us, all of our lives. Now the developers come and promise to do everything and pay for everything, and once done, they get to leave with all the money that they came for, and we will be left stuck with maintaining something that we didn't even ask for. I do have a petition. It's not a large one. It's just a sampling of the town people. There was no going around knocking on doors or anything. The papers just sat quietly in one building in the town, and these are the names. I don't know.
Thank you. You can leave it with the clerk. Why don't we keep that paper over in the corner over there, and then we can just have the next person come up. Anyone else? No? Does anyone else wish to speak in general or against the application? Going once, twice? Okay, so back to the committee. Any further questions from the committee? Somebody wish to? Councillor Taylor.
So the applicant said they'd be willing to have not the final approval with that midpoint involve council in the discussion with the site plan. I'm just wondering what that type of language would look like in this motion. If we could have that drawn up just so we could see, or like I'm thinking, how long would this normally take? Or if we could, if I could ask planning staff at what point in the site plan process would a consultation with council be most appropriate?
Through the mayor, I've never experienced this before, so I mean, we could do it after, generally there's several submissions, about 3 usually, so we could do it after the second submission maybe?
Probably makes sense, after the second, and then it comes back for final approval?
Yeah, as long as the third one is final.
Makes sense. Councillor Columbus?
Madam Mayor, I'm prepared to move the recommendation of staff, and if another councillor wishes to add that to the motion, that's fine. And I'll tell you, I'd like to move it, and I'd like to speak to my reason.
Did you want to speak first, and then we can see if there's
Sure.
an amendment?
I just think that this application's been in the works for quite some time. I think the developer's pretty patient. I know they've had issues in Port Dover. That's another thing that's come up recently. There's a statement in the report by staff that small businesses will continue to disappear if the population does not increase. And that is true. That's actually happening in very many small communities. And this council has been said many times, we're here to reduce red tape. I think we're actually increasing red tape by adding all these stipulations. So we should not be chasing any developers away, and we need the tax base desperately today, more so than we ever have. Thank you.
Councillor Van Passen.
Yes, thank you, Madam Mayor. I'd be happy to second that motion, but with the clear understanding about like not just the printed recommendation or whether we have to amend the recommendation, but that, yeah, we are going to have a look at the site plan for final approval, and, you know, there are ways of doing that. And I'll go back to that, you know, we're going to grant them an easement across our property for a drainage stormwater outlet. I also want to have that pathway clarified, that they're going to provide that pathway as access to the open space. They're going to grant the county an easement over that pathway, but it's not going to be the county's responsibility to maintain and construct that pathway. So I don't know, do we need to add that, or is that something that gets negotiated in the site plan control or process?
Through the mayor, the easement, I would suggest including that now, so that it's clear that you do want that.
And what about in terms of the parkland as well? Should we include that now?
I would suggest yes, that you should.
Okay, then we add that we will take cash in lieu of parkland.
100%.
100%, and if that's okay with the mover, then I will second it.
Councillor Shelley?
Thank you, Madam Mayor. I do want to just make the comment, and Councillor Columbus, as part of his explanation for his motion, mentioned the fact that the developer has had some trouble in Port Dover. I do want to make it extremely clear to everybody that whatever council decides in this matter, it is not some attempt to throw a bone to the developer for difficulties in Port Dover. I do believe that there is I won't say perhaps a widespread perception, but there is a perception in Port Rowan that may be the case, that we are offering up Port Rowan as an opportunity to make up for the fact that there have been some developmental delays in the building community in Port Dover. So I do want to make it clear that that is not the case in this matter.
Councillor Roberts?
Thank you, Madam Mayor. Through you, I'm in support of the motion that's before us here with the amendment. I think I wanted to reserve my comments and maybe direct them towards our development community. I feel that the developer, the agent, they've come, the builders, they've all kind of come at this in good faith. My comments about density was with regards to this could have been a much denser development, was the point I was trying to make with the R4, that it could have been arguably upwards of over 250 units there. That was the point that I was trying to make, and that what's being asked for is significantly less than that. Appreciating that we're asking for a zoning amendment that's going to, you know, double from R1. It could have been much, much denser. I've seen applications come before this council that have not been respectful of someone's backyard. I know that with the abutting properties, we have single-story units. We're not casting shading into those backyards, and I feel that that's also in good faith, that we haven't started with these townhouse units or these large units immediately up to the property line, casting shade into someone's backyard and ruining the enjoyment of their property. When you buy a home and it's facing a farmer's field, a forest, you know that eventually it is going to be potentially developed, especially if this is within the urban boundary and earmarked for future expansion in the residential zone. You know that eventually it's going to fill in. But what you don't know as a property owner is how dense that could be. That's a risk you take when you buy a property. I'm glad that there has been some concessions made, public consultations and town halls before this development has come before us, because we've seen some other developments that have not taken that course of action, and that's one of the reasons why I am supporting the motion that's before us today. I feel that you've acted in good faith, you've engaged with the neighborhood, and you sort of put your best foot forward. I've seen other developments, Bremont is one that comes to mind, that didn't engage in that course of conduct, and it caused a lot more frustration, red tape, a lot more back and forth between this council and the development community. So if this is successful, and hopefully that this is going to send a clear message to our community, our development community, that in Norfolk County, if you're building on adjacent lands, that we want to make sure that we're respecting the property rights of those homes, and that the denser areas, really those should be in the middle of the development. They should be on the lands that are not facing an abutting existing property. So those are my comments, and I stand by them, and I thank you for giving me the opportunity to speak on it.
Anyone else? I think you can get a recorded vote. Is there somewhere in the procedural bylaw that says you can at the hearing committee? I don't think so.
The definition of recorded votes in the procedural bylaw is specifically limited to council meetings.
Okay. All those in favor? It's carried. Okay, I guess my only comments to that would just be, it is such a beautiful area, and I really do hope that we're able to come up with something really unique down there. The next item on the agenda, I think that's the final report, is staff report DCS 20-19, subsequent reports to first staff report to DCS 19-130 from December 10th. It's a housekeeping amendment that applies to all of Norfolk County. It's meant to increase the accessory building height in the resort residential zone and agricultural zone, amend the attached garage. That's not the right one. Is that the right one? What's that? How did I? I got something mixed up here, sorry. So the next report is staff report DCS 20-17. That's in regards BC appraisals and agent elder plans to put forth the application affecting the lands described as 763 Norfolk Street South. And Mr. Vaughn, I guess that you?
Thank you very much. So the application seeks to permit an additional use for a daycare nursery on agriculturally designated lands. The lands have not been used for agricultural uses for over 50 years. The building on the subject lands is currently used by a contractor and accountant and will be renovated to accommodate the daycare. The daycare will contribute to accommodating an appropriate range of commercial opportunities and will serve an identified community need. The proposed official plan and zoning bylaw amendments consistent with the policies of the PPS, and the proposed daycare conforms to the policies of the official plan. The application to amend the OP and zoning bylaw represent good planning, and staff recommend approval.
Thanks, Matt. Questions from the committee? Councilor.
Thank you, Mayor Chop. Through you to Matt, this may be very in the early stages, but just wondering, do you know, are you aware if it's a profit or non-profit child daycare center?
Through the mayor, I'm not sure, but the agent is here. Okay. So, and I think the owners are here too, so they might be able to answer that question.
Does the agent wish to speak?
As agent, Madam Mayor, it is profit. Thank you.
Anything further from you or just questions?
No, I think the summary that has been presented by staff is fine. I'll tell you the contractor is no longer there. The renovations have begun, so hopefully this is positive tonight. Thank you.
Any questions from councillors? Councillor Columbus.
Thank you. Is the applicant fully aware of the official building code amendment requirements as spelled out on page 133? Because they could get quite onerous in rehabilitating a building for a different use. Are they fully aware of the requirements?
They have been in contact with the building department, yes.
Okay. Thank you.
Councillor Hoffman.
Thank you, Mayor Chop. Through you to Ms. Elder. So confirming that this child care center would be profit-making center, which I do have to say is not of the norm in this day and age, and strikes me as not compatible with our social services. Would there be subsidized spaces available in this child care center?
I'm going to have to ask the agent to come forward and speak to it, the actual owner.
Okay.
Brenda Cooper, 54 Ross Ave North, Simcoe. We would be looking at subsidies, whatever's available out there. I know that there are some, I know there's a lot of nonprofit and they do allow, or they do have subsidies. There are also profit that have subsidies as well.
Okay. When you were saying a lot of, meaning what, in Norfolk County?
In Norfolk County.
Okay, we don't have a lot.
No, but what I'm saying is the nonprofits offer subsidies and there are profits that also offer subsidies.
Okay. To my knowledge, I think there's only one profit-making center.
There is.
Yeah, and that one is leaving. Is there any particular reason why you would choose not to be a nonprofit?
I haven't sat, I'm going to be honest, I haven't sat down with my legal accounting departments yet to look at both avenues. I've just basically considered the profit at this point.
Okay. And do you have an idea how large your center would be?
We've got in there, in our paperwork, it was up to 30 is what we put. And see, ministry also designates how many spaces would be available. So we have to work with ministry as well. For this bylaw, or for this amendment, we went up to 30, according to space that we have at this time.
Okay, and would that be infant, toddler, preschool, school age, or what age?
We would be looking at 18 months and up.
Okay, so toddlers and up.
Toddlers
no
and up.
Spaces.
Yes.
Okay.
Any further questions? Thank you. Does anyone else wish to speak in favor of the application? Does anyone wish to speak in general or in opposition? Somebody wish to move the staff recommendation? Councillor Martin, seconded by Councillor Rabbits. All those in favor? It's carried. And the final report, moving right along, staff report GCS 20-18, accessory residential dwelling unit policy and bylaw updates. Mr. Vaughn, is that you?
Thank you. So I will I will try to keep it short and sweet so we have more time for questions. So an accessory residential dwelling unit report, oh, hang on a minute. There we are. Was presented to council in December of 2019, which proposed an amendment to the official plan and zoning bylaw to enable accessory residential dwelling units in the county's urban residential zones, the hamlet zone, and the agricultural zone, both in the primary dwelling and in an accessory building or structure. At that time, council requested additional information related to cost versus cost benefit, impact to servicing, the provision for basements and bunkhouse conversions. Those details have all been now included in the report. Staff still maintain that what's being proposed is consistent with the PPS. It conforms to the policies of our official plan. And one of the, I guess, other pieces that I didn't identify in our last report that is pertinent to inform council of is accessory residential dwelling units. They appear in the Planning Act, and we are actually required to accommodate these in some form and fashion in Norfolk County. So currently, we already accommodate them as accessory units in the primary dwelling within our urban residential zones. We're expanding that, looking to expand it into the hamlet area and also the ag area, and then we're also proposing to put them in accessory structures. That accessory structure piece is something that's relatively new to the Planning Act, and it's something that the Act says that we shall do. So this is something that, in addition to it just being a good thing, because it will create more housing, and the hope is that it creates some affordable and rental housing. It's something that the province feels is very important and something that municipalities have to do. With that in mind, we recommend approval. If there's any questions, I'd be happy to answer them.
Questions from councilors? Councilor Columbus.
Thank you, Madam Mayor. Matt, I noticed there wasn't much discussion about parking. That's a concern in built-up neighborhoods, in the subdivisions, like when these small units, tiny houses have company in that, and for snow plowing purposes, and just all-around parking doesn't seem to be discussed much. Do you have much of a concern about parking?
Yeah, so through the mayor, the unit itself requires at least one parking space, and through the setbacks, we've suggested there will be space on site for that parking space. Now, in addition, additional parking space for visitors will have to be accommodated similar to how it's already accommodated for the primary dwelling, and that would be on street. So I personally don't have too many concerns about it, but it is something that will be a factor moving forward.
And secondly, in the last application that we heard, there was a lot of talk about site plan. And I guess until we get to the stage, we really don't know what the impact will be and how neighborhoods will be handling this. But will there be a notice sign going up on the property that a tiny home is about to be constructed on a certain property? And will the neighbors have input into site plan issues?
So through the mayor, these units would not require a site plan application, and the decision that council's making today would enable this, provided whoever's building these units builds them within the provisions of the bylaw, there wouldn't be an opportunity to come back to council on a site-by-site basis.
Okay. And lastly, there's no mention in your report today on a tiny home community. Any thoughts about that? Like where you'd have a campground where it'd be all tiny homes with proper roadway. I'm thinking about the Cortland Trailer Park, actually, which seemed to work well for 50 years.
Yeah, so through the mayor, a tiny home community would be permitted in Norfolk today under some of our existing zoning provisions. The part that would be missing from that would be reduced lot sizes in addition to reduced housing form. So it's something that we're considering moving forward with. These tiny home communities would likely be better suited for a condo type development where we're not creating small lots in addition to small houses. It may be better suited to a community where all of these housing forms are all situated on one lot with ownership of the unit itself. So there's a couple different ways of approaching it. The main thing would be it would have to be developed within a settlement area, so it couldn't be developed, let's say, in the ag area or somewhere outside of an urban boundary. So that's the main part there.
So I guess a tiny home community would be coming in as a separate report then?
Through the mayor, if that's something council wants us to look into in addition to this, yeah, we could do that. Through the mayor, though, I'm not sure, besides looking at reduced lot sizes, how it would be much different than how developers could come in today for that type of development.
Okay, thank you.
Councilor Shelley.
Thank you, Madam Mayor. Through you to Matt. Matt, in the last report that we, council received on tiny homes, there was an attachment that had a series of GIS maps identifying the county properties that are currently vacant that might possibly or potentially be useful for a tiny home community, just to kind of build on what Councillor Columbus was mentioning. And while those maps are useful in kind of identifying the number of properties we have, would it be possible for staff to make a list of those same vacant county properties, but provide the civic addresses of each one of them, so people, I've had some inquiries from people who are interested in perhaps developing one of these communities, but they're having, frankly, the same logistical problem that I have, is that sometimes the maps are little bit hard to interpret if you look at the maps I'm referring to. And what I'd ask further, is it possible for staff to perhaps prioritize a list of 5 or 10 or a dozen such properties according to their, perhaps being the more suitable locations for a tiny home community, if that's possible.
So through the mayor, you're right. We did a GIS exercise where we looked at county-owned lands and looked at them for suitability. That study actually showed that the majority of the county-owned lands that are vacant actually are not suitable for that type of development. They're either provincially significant wetlands, they're hazard lands, they may not be zoned appropriately. What that study showed was, if council wanted to move forward with owning property for this type of development, it would likely be something the county would need to acquire outside of the lands we already own. And then we're talking about either the county being a developer or the county purchasing the lands and selling it to a developer, or some sort of a partnership.
Madam Mayor, if I may. So Matt, just for clarification, so the current vacant lands that the county owns, none of them would be suitable for a community like?
Through the mayor, by our account, there didn't seem to be very many suitable spaces for that. One of the suggestions that council put forward was looking at access parkland, or maybe looking at other institutions that aren't using their land fully and seeing if there's any partnership opportunities with those. That's something we could look at, is looking at parkland as another option. But that would be something we would need some direction for council on.
Well, then, Matt, would it be appropriate for me to perhaps ask if you were able to provide council with a list of the parkland properties that might be suitable for a tiny home community?
Yeah, through the mayor, that's something we could do.
Matt?
I guess one of my questions still on the servicing side, I mean, I understand that we have a bylaw that for on the water side of things, that's only allowing for one water connection, but there's nothing to say that we wouldn't be able to change that. And I understand the idea that was done in the past because they wanted to minimize the sort of make it easier for the uncollectibles and that kind of thing. My challenge is, when I went home and I looked at my own water and wastewater bill, the bulk of my bill is the flat rate. The flat rate delivery piece. And so I don't see this. Why should the other users in the system bear a greater cost than somebody now that goes and builds a tiny home. To me, they should still be having to contribute to their share of that flat rate, the idea of the water plant and of the lines to make it to that property. It's not necessarily, I don't know. I guess this is what I was kind of hoping for. Maybe there's a way that we change within our water and wastewater rates that if you have a tiny home, yes, it's off of one water main, but you are still responsible for that additional flat rate to your property, given that it's two separate homes. Something like a basement apartment obviously is very different because it's within the house and that's existed for a long time. But to me, if you have two separate dwellings, the idea is that you're saving on the cost of a home. We're going to have a marginal tax increase, but we're going to put all the same strain as a person living in a regular home versus a tiny home. We're going to put the same additional strain on our facilities. But as we look to expand those facilities, the number of users is going to stay the same. Meanwhile, we could have theoretically doubled the number of users. Do you see what I'm saying?
Mm-hmm. Yeah. So one of the options there, and this is how it is right now, but it is proposed to be changed, is those units would still have to pay development charges. Accessory structures would still have to pay development charges in the urban areas. So the idea is that those development charges go to help paying for things like those services. That's being proposed to be changed at the provincial level so that those units would be exempt from development charges.
But even more so then. So now they're exempt from development charges, but they are putting additional strain onto the facilities, not just on water consumption, but on the actual infrastructure in our facilities.
Yeah, unfortunately I can't speak for Public Works, and no one is here to speak for them, but I'm assuming that's something we could look at changing, looking at the water rates and trying to figure out how we adjust our existing policies around how we charge based on whether or not if you have one of these dwellings on site.
Like just one other piece with this in terms of, we're, I think, around $60 a month, at least for the flat rate for water and wastewater on a normal residential home. So, you're $720 a year. Even if we looked at those that are uncollectible, we surely would still be coming out ahead by collecting that additional $720 on the majority of them. Councillor Van Passen? I know you're of the mind of the single. It's not a matter of the one pipe or two pipes for me. It's just a matter of we're losing $700 a year towards the collective of what we need for expanding our plants and the flat rate.
Now I get to disagree with the mayor once in a while, but I just want to get out of here at the end of the day, giving staff clear direction on what we want, how we want it done. And, we sent them back once and they've answered a bunch of questions for us. But see, I look at this from a different point of view, that the last report we got from the Workforce Planning Board is there's 1,200 jobs available in Norfolk County, but nobody's taking those jobs, and the biggest reason is they can't find a place to live. We shell out between Hallam and Norfolk that we look after almost $7 million in subsidized housing. We cut checks to people to help subsidize their housing because they can't afford to find a place to live. If we can create the environment where the private sector would build the housing that is affordable, that people would have a place to live, or you could put the accessory dwelling in the backyard and move grandma and grandpa into your own backyard, and that would free up their home for somebody to live in, whether put on the market as a sale or whether it's a rental. So is the goal to try to develop a system where we can collect the most amount of money on building an accessory apartment or accessory dwelling, or is the goal to create the environment where we can get new people coming in who can fill those jobs and the county can prosper, and that's where your money will come down the road? So is it better to try to pick up $50 a month here and there on a couple of meters, or is it better to make the system easy, quick, simple, and try to get it to grow that way? And the province, have they approved that where on the first accessory unit you're not allowed to collect development charges, or are they still talking about that?
Right now, if it is attached to the primary dwelling, it's exempt. If it's in an accessory structure, currently it's not exempt. The county would charge an apartment type rate to that type of unit.
Yeah, so like I would like to walk out of here today having very clear rules of the game that, you know, you want to build something in the backyard, go ahead, but here's the side yard setback, here's the rear yard setback. You know, I would much prefer that it just hooked up on the current services, that we don't have to cut open roads and dig up front yards. You just got to hook it into the existing water system, you got to hook it into the existing sewer. That's our current policy for the water department. I don't think we have a policy under the sewer department, but that's the way I think it should be. Development charges are laid out pretty clear in the provincial legislation, so don't even want to go there. Why touch that? But let's give that clear direction so that everybody knows the rules of the game going into it, and I don't want to change it and make it more complicated. I want to make it simple. So I would leave it to the rest of council to either agree or disagree with those statements, but let's get out of here at the end of the day with something that is definitive, not little gray areas.
If we didn't just have a 16.8 increase on the water and wastewater, I would tend to agree with you. But I'm also just thinking in terms of fairness and equity. I don't think that that would deter somebody from building a tiny home because they have to pay their fair share of the water and wastewater. They're still getting a good deal at the end of the day.
I think that I might have made the comment during that discussion on water and wastewater that the majority of the funding shortfalls we have is to replace long-term capital projects, which in my mind should be funded by the base rate rather than by the operating side of it. So why wouldn't we be looking at, rather than as 16.8% across the board, you should have looked more at increasing that flat rate fee to pay for the replacement of the original infrastructure, and maybe raise that, double the flat rate and lower the actual ongoing cost that covers what it takes to get water to run through the pipe. Maybe we have to look at it more so that way, but I think we discussed it a bit at capital budget time or at operating budget time, but that would be my point of view. But then again, I'm not the expert on it, and neither are most of my constituents in Ward 4. We're not real experts on the water and wastewater sewer systems in Norfolk County because none of my constituents are hooked onto it. So.
Fair enough, but if you were to take that approach, which I actually agree with, but you raise that base rate, now you have one spot where you have a couple families, or may not be families in the tiny home, but two separate units that are sharing into that now larger base rate than somebody else that is just living in their small house in Simcoe that is having to take that on by themselves. That's my only point with it.
How far do you take that? Like if we would have lived in town when I was younger, there were 7 kids, mom and dad and my grandfather living in one house, and my neighbor across the road was a widow lady. Does that mean if you got more kids and more people living in the house that you got to start paying more or change the rate or put in 2 meters? Where do you start drawing the line on that?
Arguably, you're paying more in the amount of water that you're drawing.
Yeah. And the same will happen if you have an accessory home. Whether I move my grandmother in with me into my primary residence or I build an accessory home in my backyard, between me and my grandmother, we're not going to use any more water, whether we live under one roof or we live under 2.
But why not? I get the tying into one water line, that's fine. Why not have a charge, though, under our bylaw that incorporates the additional dwelling? So that it is fair for everybody in Norfolk. So that one person that's not building a tiny house isn't disadvantaged by somebody else that is. That isn't going to be responsible for upgrading infrastructure because of all the additional draw that's coming on the system.
Because every one of them needs to have that water plant somewhere.
But when that water plant gets to capacity, as we've seen now, we had to raise water rates because now we need additional capacity.
Yeah, but the same is true with under the current system, under our current policies, that there's only, for every property, there is one water source and 1 meter. So whether that be a tiny home, whether that would be a small home, that would be a large home, whether it's a townhouse unit with 6 units on it, it's still only going to have 1 meter. They're only going to pay the one charge. So I don't see how that's connected, unless you're going to change the entire system. You know, if there's a house in the backyard or that house was attached to my house, it's still only the one property. Right?
Is that true with the townhouse? That they're not paying multiple flat rates? You sure?
Well, if our current policy is 1 meter per property, we know we just dealt with there's going to be 136 units on 1 meter, right? There's only going to be one water meter that bills a development in Port Rowan, right?
See, that to me is not fair. Why should 136 units not pay their flat rate, but every other person in Port Rowan, the people that were sitting here, they each have to pay a flat rate? Why do you get a windfall? Because
maybe next year when we're discussing the rate-supported budget, we make sure we keep this on the agenda, right?
for additional units. It's per unit and not, that would be fair enough. That's something that we could consider then. I had one other question too. Oh, just in terms of, what are some of the towns, Matt, I'm sure you probably looked into this, but I'm just curious your perspective. It wasn't in Victoria, it was somewhere in BC though, where there was almost an overabundance of tiny homes like that, popping up in people's driveways, and, it got out of control and was kind of a model of what not to do. Did we look at that?
I'm not familiar with the exact locations, but we did do quite a bit of research, and where municipalities don't have zoning provisions in place for things like setbacks and parking requirements and the location of the unit in relation to the primary unit, it's a free-for-all, and it becomes very messy very quickly. So having some parameters in place about the location of the unit, especially in relation to the primary unit, it helps. It helps maintain a good character for the neighborhood. It helps maintain some order so that at least they have somewhere to park. And I think the discussion around how water is, the water rate and how that's allocated to the new folks living in that unit, I think that's a good discussion and something that we could look into to make it fair and equitable, like you say. That's something, that's something if council wanted, if you wanted to, staff to look into that, we could look into that. But I think it's something that we could look into, even if you were to approve this tonight, it's something we could look into in the future to change.
Well, I guess the thing would be to bring a report before next year's water and wastewater budget to show, if that is the case with townhomes or so on, to show how many additional units that would add on to the system. Okay. Any further questions from councilors? Councilor Martin.
Thank you, Mayor Chop. I have something completely unrelated, but I just wanted to plant this seed with you, Matt. I wonder if throughout your research and as we continue to invite this type of development into Norfolk County, if you're ever on any webinars or in discussions with the province, one thing I have stumbled across in Port Dover is waste management and the rule with composting and trying to reduce waste for people is 1 unit per home. This is a green, sustainable housing initiative, and I can see people wanting to, I can see trouble coming down the road potentially with garbage and waste, so you would really want to minimize pickup at the road. So I know it's a provincial policy to not have more than 1 composter on site, but I wonder if I could just plant that seed with you. If any discussions ever were to arise or the topic was to come up and you were able to put a bug in someone's ear on the provincial level about composting and just maintaining that type of green lifestyle with these secondary dwelling units on the property, I think that would be helpful.
Yeah, through the mayor, excellent point. And something for the entire county to think about moving forward, having mandatory composting. It's a great idea.
Further questions from councilors? Somebody wish to move the staff recommendation or propose an alternative? Councilor Taylor? Seconder? Councillor Michele, further discussion? All those in favor? And it's carried unanimously. Okay. I believe that's it. Is that the last one? I guess with that, public hearing committee is adjourned. Thanks. Have a good night. Oh, unless anybody has any general announcements or anything before we leave. Staff, anyone? Okay, very good. Have a great evening.